Sarah Boone has issues with her 8th attorney. Are you really surprised? There's a new letter that's going to be posted soon. Maybe we'll take a look at it. Probably will take a look at it because I'm nosy. But she had her hearing today, and her trial is not set until, well, who knows? Maybe there'll be some issues with her 8th attorney. Maybe we'll just keep pushing back. Maybe this is what she's trying to do. Maybe she doesn't want to even have her trial. You know, in her letter, she's like, I want to have my trial now, blah, 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 blah. But maybe she's trying to push it so far out, saying that she has issues with her attorney that she thinks maybe they're just going to be like, hey, you know what, Sarah Boone, we're just going to release you. Yeah, we'll just release you out into the wild. But let's listen to our hearing, and then we also are going to listen to the cross-examination. I think there's been a little bit of direct examination, but cross-examination of Trooper Buchanan for the Karen Reed trial. That happened, I think it was yesterday. Yeah, it was yesterday. Oh, God, I'm a little bit late. Hi, Taxi. How are you doing today? How's it going? But let's start off with Ms. Sarah Boone. The title says, please be nice to me. Sarah Boone complains about 8th attorney. I mean, honestly, I thought things were fine with her attorney because, you know, I periodically check the Sarah Boone court stuff online, and it seems like her attorney is getting things done. I'm not seeing new letters from Sarah Boone, so I'm like, oh, maybe things are working out. Good. Let's have the fucking trial. Let's go. But I don't know. There might be issues.
Judge, I've obviously not seen the letter.
Oh, is this sped up? I'm sorry. Is this sped up? I'm going to do normal speed. Hello, Charlene. How are you doing today? How's it going?
Ms. Boone is correct. She has walked out of the last 2 visits when I've tried to review things with her. Just so the court knows, I've spent probably 20 hours, a little bit more, a little bit less, with Ms. Boone. She has lots of lists, lots of questions in reviewing the court file.
Look at the judge's face. This is a new judge, by the way. This is Judge Kranick. So new attorney, new judge assigned to her case, but look at the judge's face because he knows the history of Sarah Boone. He knows how many attorneys she went through. Some wasn't her fault because there's like some conflict of interest, but there are some where it seems like they weren't getting along with each other. Maybe Sarah Boone wants to take a different direction than what the lawyer wants to present, or maybe Sarah Boone wants her lawyer to do something that's maybe unethical and the lawyer doesn't want to get involved in this shit. But look at the judge's face right there. He's like, oh gosh. Oh boy. I'm trying to zoom in a little bit. Hi, Chantal. How are you doing today? How's it going? So she said that Sarah Boone has walked out on 2 of their meetings so far.
She was distressed previously about having access to her lawyers. I have taken collect phone calls from her that are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have
Hang on, please. No one's interrupting.
Whoa. Was that Sarah Boone trying to interrupt in a formal court proceeding? It sounded like her mousy ass voice.
Interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours going through her questions, going through her lists. When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference. When I tried to...
Wait, why? I thought she wanted to be involved in every aspect of this. I wonder if she doesn't like the defense that her attorney is suggesting her to go with. I mean, it seems like they're doing the battered spouse defense. Hi, Moondog. How are you doing today? No, I do not want her to represent herself. Please, no. I don't like it when they represent themselves, especially if they don't know what the hell they're doing, because it wastes our time. It wastes the court's time. Things are much slower. The judge has to spend time explaining things to them. They don't know fuck all. Like, no. Just stick to a public defender. Or maybe Nettie and Jackson would be like, hey, we'll do pro bono for Sarah. I'm just kidding. They're totally not. Who wants to deal with her, okay? Ain't nobody going to do that pro bono.
Review some things with regard to discovery as to things I wanted to make sure she was aware of. She walked out. She has asked me repeatedly for a copy of some medical records.
Medical records? I wonder if she's purposely being difficult to make it so she's trying to get the public defenders to quit on her over and over and over. So in the future, she's going to be like, look at this. I'm just trying to have my case tried. I've been working with so many public defenders and they're just all doing me wrong. Like, this is so unfair. I've been locked up for 4 to 5 years waiting to have my day in trial. It's not my fault. It's the lawyer's fault.
Based on the discovery I got from the previous attorneys,
this must have happened in a movie or something. Was there a movie that they played in her little jail that she watched and she's like, oh, good idea, I'm gonna steal this from the movie and then see if it's gonna happen in real life?
One of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy.
Oh, maybe medical records that she had, because her and her boyfriend, they have had some domestic violence issues in the past as well. I think he was arrested in one. She was in trouble for another one. Like, it seems like it was a very tumultuous relationship. So maybe those are the medical records that she's trying to get. Like, hey, look, see, he's been abusive to me in the past. Here are the medical records. But, you know, I think the prosecution is going to show that she's also been kind of physical with her boyfriend as well. And they both were, you know, they're both reprimanded by law enforcement. I feel like, I know that he was arrested prior for what? I have to go through the records because I don't remember. But I could have sworn she also got in trouble for it too. It seems like they both were just, you know.
Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client. You know, I know the court's in a difficult position, but at this point, we're at that impasse of, if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
She's like, Judge, please get me out of this. I don't want to deal with her anymore. I'm trying my best here, you know. Is this the influencer chick? You know what's funny? She kind of does look like that YouTuber. And I say YouTuber because she did make YouTube videos, but I don't know if she was like famous on YouTube. But do you guys remember there was a YouTuber who she like, it was like a murder for hire. She hired like these 2 guys to come over, staged like some fake robbery and kidnapped her husband. But there was like a body cam footage of when law enforcement arrived, and then you could see how she was acting, and it was just like, it was just off. It was like, this is like kind of off. I don't know. I forgot what her name was, but they kind of look similar. I know who you're talking about though.
Ma'am, you said there was something else that you had other than a 58-page submittal or letter. What other information is it that you're seeking to have me take?
What? Did he say 50-page letter? Hold on a second. So she's got like, it looks like there's a stack full of paper right there. They have not been uploaded to the court's database yet, but 50 pages. Oh my God.
Ma'am, you said there was something else that you had other than a 58-page submittal or letter.
58-page letter. Oh my God. We've seen the Sarah Boone letters before, spanning from 4 pages, 8 pages. I don't think we've ever seen anything more than 10 or 50, or maybe we have. I don't think so. 58 pages? Dude, she's trying to write her like life story on there. I don't know. Maybe she's just waiting for attention at this point. I'm baffled.
What other information is it that you're seeking to have me take a look at?
It's things that I've been working on in the meantime. It's things that she likes to tell me is not necessary, but I know for a fact it is necessary.
So she thinks she knows more than her attorney. And I wonder how many other attorneys told her the same thing, where Sarah Boone's like, no, this is necessary. And the attorneys are like, no, Sarah Boone, it's not necessary. I wonder how many other attorneys told her the same thing. She literally just wants an attorney that's going to be her yes man.
Likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me I have told her from day one that her snotty attitude was inappropriate, and I try very hard.
Imagine working with your public defender and on day one, you tell them your snotty attitude is inappropriate. On day one. It would be a difference if it was like, day 5, day 10, and you've been dealing with it for some time. Because usually initially when you deal with someone, you don't like the way they are. You're just kind of like, oh, maybe it's just like an off day. Or maybe I'm interpreting things wrong. But no. Sarah Boone's like, I don't like your snotty attitude. Oh, gosh.
To bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she supposedly represented my life.
Okay.
And she's like, I don't know what she has against me. I don't know what she has against me.
Give me an example of, if you could, of items that you believe are important. Ms. Cashman is not giving attention to or dismissing as you may have framed it.
Yes, please be specific. We would like to hear that. I like how the judge is, he's inquiring because he wants to know too.
Yes, Your Honor. She likes to tell me that I don't like her answers. She's not giving me any answers to this.
What did she say?
I've written 3 pages worth of questions, but she's not giving me any. She likes to tell me that I don't like her answers.
She'd like to tell me that I don't like her something. I didn't know what she said. Maybe I don't think captions are going to help us. We'll try. Fire, hello, how are you doing today? Joe, hello, Tuco, how's it going? The trial is set for October so far, but if she has issues with her attorney again and again and again and again and again, she'll never have her trial.
She's not giving me any answers to this. I've written 3 pages worth of questions, but I'm still waiting for her and any other attorney to actually answer for me.
Oh, okay. So she had a bunch of questions written down, and she's saying that her attorney is not spending time answering them. But this is not the only attorney who has done that. Other attorneys have done the same thing. So when it's a pattern with a bunch of other attorneys who are doing the same thing, Sarah, maybe they really aren't important. Maybe you're just asking frivolous questions. Maybe you're wasting their time, truly.
Such as, why can't I have a bond? Why can't I have a download of my phone? Why can't I speak to my investigator? Why can't I have my medical records? Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I have.
What constitutional rights specifically?
I'm very leery about having a fair trial at this point.
Okay, you're not answering the question, so maybe she'll get there. So do you see that hesitation right there? The judge is like, oh, okay, what are the constitutional rights that you're referring to? And she's like, fuck, I don't know the answer to this. Let me see if I can give a long-winded answer. I don't know, maybe she'll get to it.
There's a handful of other amendments that I have been researching and working on and trying to incorporate.
So there are other amendments that she's researching and trying to incorporate, but she's not listing the amendments directly.
To me, what I have written to you is obvious, and apparently from...
Oh, and it's obvious, but I don't know what they are, but it's obvious. It's in the amendment somewhere. I've done my research. It's obvious, Judge.
The correspondence that I get from the world, South Korea was the last place that I received correspondence. They obviously see the same thing.
She got correspondence from South Korea? Is that what she said?
So I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I believe that God obviously believes in me as much as I do him in order for him to give me this very unique adventure that I am on, and I'm doing my best to...
Oh, I just noticed the Court TV text update. Sarah Boone, once again, unhappy with representation.
Let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always... The reason why I'm here is hope. Is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying.
See, sometimes when you're dealing with a personality like Sarah Boone, you start off pretty soft, but then when you start realizing that the person on the other side of the table is a fucking asshole, yeah, you start to have to amp up your personality a little bit and be a little bit aggressive. You can't just let someone like Sarah Boone step all over you.
And see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and in more than one way.
Right. She doesn't want people to see her as a malicious murderer. But the issue that we have is that there is a video of her taping her boyfriend zipped up in the suitcase. He's trying to get out. He's like begging her. And she's just sitting there laughing. That's pretty fucking malicious. Oh, God. She's like so delulu.
I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me and have a welcoming attitude, and things will probably change, and I will not get up and I walk out. Please don't lie to me. Please don't give me half-truths. And
What instances where there's...
Right. The judge is trying to get specifics, and she's just kind of rambling on and on at this point. Initially, his first question was, okay, so what are the constitutional rights that you're referring to, right? And she's like, I don't know. There's like some amendments. I've done my research. I don't know. It's pretty obvious. And then now the judge is like, okay, well, give me some specific like incidents, right? I can't imagine someone like Sarah Boone telling people, please just be nice to me. It's like, oh God, I feel like Sarah Boone seems like the type of person who's just like super fucking passive aggressive. And at some point it's just a straight up asshole probably, and just really aggressive. We've seen tinges of it through the police body cam, through her interview. Like we've seen like hours and hours of footage of you, Sarah Boone. And not only that, we've seen the letters that you've written. She doesn't seem like a very nice person.
Been falsities or lies that have been told to you by Ms. Cashman? Can you give me an example?
my biggest one, Your Honor, is for me being here ongoing 5 years, no one has ever bothered to try to get me a bond.
What's the lie? You said that she has lied.
Oh, she wants to get bond. So what is the lie? Your Honor, I'm on trial for murder, and where's my fucking bond? I want to be out on bond.
To you, what is the lie?
The process of getting a bond. She lied to my brother in regards to telling him that he would need to come down to the courthouse to have multiple photographs taken for documentation. He would have to bring the security information, deeds to his house.
Oh my, there's so much to say here. Where do we begin? Let me bring back in my friends, Tommy Pope and Mike.
I think there's more court footage here. All right, we'll listen for a little bit, and then we'll go back to the court footage. Fry, thank you so much for the what. Yeah, I mean, at this point, I feel like she's just doing it on purpose.
Michael J. Brown. Okay, so we're on lawyer number 8. God bless this woman, Patricia Cashman, the attorney. We just saw the back of her head, the blonde curly hair, addressing the judge, saying she spent 20 hours with Sarah Boone. She's even taken collect calls at her own expense. She serves with the Office of the Public
Not getting reimbursement for that.
Defender there, and has taken calls that she's had to pay for out of her own pocket when she's not making a lot of money, you know, because she wants to be devoted to her client, and her client is walking out of discussions with her, and they have reached this impasse. Tommy, Sarah Boone has had a problem with every single attorney. Do you think the problem is Sarah Boone?
You know, at some time, you know,
It might not be Sarah Boone. It might just be all the other attorneys, you know?
you've been through 8 or 9 relationships, and it's always them. Maybe it's not. You know, I was thinking as she was talking, inside Miss Cashman's head is, "Oh, Judge, please relieve me. Oh, Judge, please relieve me."
Yes. She's like, it's like her attorney didn't put in a motion to, what's it called again? Motion to, oh, fuck. I forgot. It like completely left my head. Maybe he'll say it. It's basically saying that, like, okay, you know, there's a conflict of interest. I can't represent her anymore. I just can't. Get someone else to do it.
Because, you know, the defendant was saying, "Oh, I don't want her to leave. I just want her to be nicer to me." Michael could probably shed some light on this. I would be terrified to be held hostage, you know, by this defendant, because I think what she's really doing, she is effectively denying herself of counsel. You know, you've got a right to be present in the courtroom, but if you have misconduct, you can be removed. We've seen that in other cases. I think that's in essence what she's doing.
Motion to withdraw. Yes, thank you. Motion to quit. I like that too. Yeah, motion to withdraw. Thank you.
Here, I don't know what state, you know, and what their rules are, but it
Motion to GTFO.
seems to me a matter of time you're going to have this, because she thinks she's smarter than all of her attorneys anyway.
Right.
Just go ahead. It'll be misery, but let her represent herself. I think the worst scenario, and again, Michael could shed some light, I'd hate to be a defense attorney.
No, don't let her represent herself. I mean, at some point, I guess she might even have to represent herself. But that's just like such a waste of time. I don't know. Like when I saw little bits of Daryl Brooks, and it was just like a mess. It was just like them trying to explain to him normal court procedure stuff, because he doesn't know fuck all about it. He's like, oh, I did some reading. It's like, okay, yeah, sure, whatever. But like, I don't know. It's just a waste of time. But it might have to be that at the very end of the day. Yeah, she might have to. You know, she's not happy with anyone. It's like, if you can't afford attorney and you don't want to deal with the public defenders that have been assigned to you, then I don't know, man. You might have to do it yourself. Maybe call in a favor from a family member, friend who is a lawyer or something like that. I don't know. I don't think anyone's going to.
Attorney tied to this client.
Oh, yeah.
I mean, I guess basically you'd sit there in the courtroom, let her run her mouth while you checked your messages
Right.
and worried about your bar license.
Right. You know who I'm thinking of? Our friend Kirk Nurmi with Jodi Arias. You know, I mean, poor Kirk wrote a book about it. His life with Miss Arias. He's never been the same since. God bless him. Great guy.
Oh, yeah. Poor Kirk. I don't think Kirk is an attorney anymore. He was a public defender. He was defending Jodi Arias. I think he tried to withdraw maybe like a couple times because he didn't want to represent her anymore and kept getting denied.
It saved her life, by the way. So, yeah, Sarah Boone, okay, obviously she is the common thread with all these problems. Are all these 8 lawyers bad? No, they're not. We've seen them in court. They are excellent attorneys. She's fortunate to have them. Michael, I want to know what you thought when we heard Sarah Boone speak after she tried to interrupt her lawyer and the judge quieted her down. And she goes, I just want her to be nice to me. I want her to be more loving. She's not a therapy dog. She's her lawyer. Michael, what do you think?
She's not her therapy dog. Oh, gosh. Okay, let me go back. I think there's more.
She's seated in the jury box.
To her, and it turns into everything else, and it turns into all these other different stories.
The audio is bad, so I'm just going to do it slow.
It is addressing the judge as she's seated in the jury box.
Because she can't afford it, Mad Hatter.
To her, and then it turns into everything else, and then it turns into all these other different stories of why she won't do or why she has said certain things. It always changes and it mutates after I ask her for certain things, not just for the bond, but for other things also.
Okay, well, let's focus on the bond issue because you said that she's lied to you, and what you've told me so far, none of that is inaccurate.
So how is it though, because I don't have any experience prior to this, I don't know the process.
Oh my God, she just said that she doesn't have any experience prior to this. So why did you think she was lying to you then? Why did you think that you're in the right? Obviously, your defense attorney, Patricia Cashman, has experience. Why did you think she was lying? It's so confusing to me. When one person has experience versus someone who doesn't have experience, and she's admitting she doesn't have experience, but she's like, oh, but she's lying. How do you know she's lying?
Process of getting a bond other than what I have read, and it's just for her to do a bond, a motion for a bond hearing. But I didn't know that anyone, all of the other inmates, even officers, have ever said that they've had to do that process.
Oh, she's comparing her experience with other inmates and stuff like that.
In order to have photographs taken and documented and news crews and visit to his house, he's not posting my bond, which I told her 1,001 times.
I mean, their cases could be completely different, though.
She still spooked him by asking by him something that he's going to have to, and it would threaten his security clearance considering he's in the service, the military. So she totally deterred me from having my brother's address in order for me to have a motion for a bond. No one else has even bothered to even ask me for one, and I will be honest with you in the court. I know for a fact that however sky high my limit would be for my bond to receive, I know for a fact unless my fans would set up GoFundMe pages or God's will or however else it is he planned on for me.
Wait, I'm sorry. The audio is so bad. Is she saying that her fans set up some GoFundMe pages, or is this her way of getting her PSA out there? Like, hey fans, send me a GoFundMe page. I have to go back a little bit.
She totally deterred me from having my brother's address in order for me to have a motion for a bond. No one else has even bothered to even ask me for one, and I will be honest with you in the court. I know for a fact that however sky high my limit would be for my bond to receive, I know for a fact unless my fans would set up GoFundMe pages or God's will or however else it is he planned on for me to have it paid, if at all. My point is to utilize my rights to have a bond. And with the information I have included in here to you, for the amount of saturation of publicity, there's nowhere that I could go even if I were to be at, in quotes, flight risk because of the amount of information that everybody already knows about me, what I look like, and what I eat apparently, and so many other things. There's nowhere I could go if I were to even think about being a flight risk. It's just the fact that I would like please to have a bond so I can say that I actually achieved something.
Okay, we're going to address bond in just a second.
Okay, so she wants to be out on bond, essentially.
But that's
And she's like, well, everyone knows what I look like. It's not like I'm going to go anywhere. It's not like I'm going to do anything. It's not like I'm going to be out there terrorizing other people with my entitlement and attitude.
back the truck up here for a moment. Did you guys hear what I heard? That she said, my fans? Did she say she has fans because she's gained notoriety by being a defendant in a homicide
I want to go back to the courtroom. Okay, it's a bit longer.
case? The homicide of her boyfriend? Did she just say she has fans? Let's go back into the courtroom and listen now.
Yeah, it's delusional.
Never told me he had to provide pictures or deeds to a house. What it said was the media's been in the courtroom for all the hearings, and it's likely that they would be there for the bond hearing, and that your face could be on the television, and it was a concern for him. And I'm gonna just leave it at that. But Judge, I can't spend all my time defending what I'm doing and at the same time be effectively preparing a case
What do you call those again? Hybristophiliacs, right?
for trial. In these situations, I know it puts the court in a very difficult position.
Hi, Lily. Yes. As you can see, once again, unhappy with Rep.
As I see it, Ms. Boone has a couple options. Number one, she can ask you to represent herself.
And you know what? She's not the only attorney who has said that. The previous attorney, Frank Berkowitz, also said that in his, it might have been in his motion to withdraw or something when he was addressing his issues with Sarah Boone. He's like, you know what? Let her fucking represent herself then. Because no one's going to ever be happy. She's never going to be happy with anyone. No one's ever going to satisfy her. It was like something of that sentiment. I think Frank Berkowitz said a very similar thing.
She has the right to. You have a Feretta hearing and determine whether she's capable. The court then has to address the issue of whether it's appropriate to appoint standby counsel. Obviously, since she believes not a word that I say after 40 years of doing criminal defense, I'm probably not the right lawyer for that. The other thing is she gets one last lawyer, it either works or it doesn't. And sometimes, unfortunately, the court gets put in a position that you have to have that
Oh, thanks. They cleaned up the audio.
conversation with a client that you don't, if you want your counsel of choice, then you need to hire your counsel of choice, and everyone can certainly do that. And if you're indigent, the court can only go through this so many times with Miss Boone coming to the court and there ending up being irreconcilable differences, such that the counsel that you have appointed can't move forward and provide effective assistance to
She's like, Your Honor, Ms. Boone is just wasting time and taxpayers' money.
counsel.
Okay, here's what we're gonna do. I'm inclined to go ahead and figure out.
Patricia
Oh, what? Why did we cut off there?
Cashman is right. She has an obligation under the law when you sign up to do criminal defense work to provide effective assistance to your client. Lawyers can get in really big trouble with that. I mean, cases can be overturned because of ineffective assistance. Someone can lose their law license if it's really bad, depending on the circumstances. And as you can see, that's not the case here. There's nothing ineffective about what Patricia Cashman is doing. She's done the court 42 years. She has
And ain't nobody wants to put their career in jeopardy for Sarah Boone.
served and practiced criminal defense work. Any defendant would be lucky.
Like, you might hate your client, you might not like them, but you're gonna do your best to represent them. And you know what? At the end of the day, it's like once the case is over, right? You move on to the next client.
Have a seasoned attorney like that, who does, by the way, appear to be very nice and pleasant. As the judge noted, no lies are being discovered here. Just so you know, my friends, our video signal's been taking hits. That's why
Well, there's also like appeal stuff too, but
coming out here a little more frequently and sharing some of my analysis with you. We're good. We've got the video back. Let's go in together again.
My last week of my period is the first full week of August, and it starts again on the last full week of August. So we could set it then, but I know that you have trial case management with Judge Marquez on.
for those of you guys who are joining us, the judge pointed out earlier that Sarah Boone has a 58-page letter. It has not been uploaded yet. I'm sure it will be. Per the court, defendant advised the court of her concerns with her attorney. Attorney Cashman addressed the defendant concerns with the court. The court took under advisement and will readdress prior to trial. The defendant provided the court with letter. And he mentioned it was 58 pages.
On the 20th or the 21st of June, which may impact that. So,
And I have a trial certain with Judge Harris August 5th, and
as do I.
August seems a bit difficult for me.
Word for a week.
Under her story, it says, Torres assaulted her for talking to a guy at a bar. The decedent dragged her upstairs and kicked her in the eye.
For Mr. Robinson, yes. So,
I know, right? It's like 58 pages. Well, maybe Sarah Boone did the college essay thing where it's like, okay, it's double space. You leave like a lot of margins. Write in big font.
the options that I see it are, we could specially set this for the week of August 26th, or we set it for the trial period beginning September 30. The hiccup with that first week of September 30 is we have a court holiday on Thursday, October the 3rd, which would limit us to a
October. What's a holiday in October? Indigenous People Day? What's October a holiday?
4-day trial period, which I don't believe is not sufficient. So that would take us to either October 7 or October 14. So based on the court's trial calendar, that's what I've got available. August 26th, October 7, or October 14th.
I think the October 7 or October 14th is more realistic, Judge. I know that Mr. Cacciatore has other trials too, and other things on other judges' pretrial dockets and those things.
We're specially set in July and in September. Mr. Cacciatore?
I think we can, I think October 7th
Mr. Cacciatore is like, I'm just glad I'm not the other side of the council table.
is fine.
Okay, so here's what we're going to do. We're going to specially set this matter for the second week of the September 30 trial period, beginning Monday, October 7th. We will set this matter for trial case management on the 24th of September, right? On
What?
September 24 at 9 a.m. Oh, yeah, that's a good idea. We'll do you at 1:30 in the afternoon.
Wait, what? Because her trial is set for October. Oh, no. Patricia Cashman's like, no.
Tuesday, September 20th.
Tuesday, September 24 at 1:30 in the afternoon for our trial case management. Trial date certain on October the 7th.
It's Tuesday, September 20th.
Tuesday, September 24 at 1:30 in the afternoon for our trial case management. Trial date certain on October the 7th. Deputy, if you could please grab the 2 packages of submittals from Ms. Boone. Oh, I thought it was 2 different envelopes, ma'am. Okay. I will review that, and after the review, the court will either issue an order or set this matter for hearing based on what it is that's been presented by Ms. Boone. Mr. Cacciatore, anything else we need to address this morning, sir?
Not the same.
Ms. Cashman, anything else we need to address?
Not that I'm aware of it this time, Judge.
Ms. Boone?
I mean, I feel bad for his family. The victim's family is probably like, what the fuck is going on? It's never going to get resolved. That's what it's going to feel like, at least.
Is there anything else you need to...
Well, she didn't put in a motion to withdraw. She did make some comments, alluding that's probably what she wants, but she didn't put in like a formal motion to withdraw.
bring to my attention at this time?
I'm grateful for your time. I was forgiven for having to utilize it. But I really do hope that you can review thoroughly what it is that I'm asking for from my attorney who's supposed to be representing me for the trial that's supposedly happening in October, late September. So if you could please, I don't understand how I'm supposed to be able to go into a trial when I don't have what it is to properly defend myself.
Ma'am, I've asked for your submittals. I will be reviewing them. All right, thank you. All right, y'all, thank you very much. Have a great day.
Thanks, Judge.
Ooh, you need a deep breath after that. I feel like I need some Tylenol. Let's hit the pause button here as Sarah Boone is escorted back to court. We'll watch this video. She exits the screen. Back to jail she goes. No adjustment on her bond. I don't know what she expects. This is a homicide case. Very rarely do we see somebody out on a bond.
Sarah's birthday is 10/10. I think I remember she's in October, baby. Oh, my Lord. Okay, so that is Sarah Boone. The judge has mentioned there is a 58-page letter, but maybe it's No, I don't know. I was like, maybe it's like double page, but it wouldn't matter anyways. Double page or single page. All right, well, keep an eye on that. Sarah Boone, y'all. That's the update that we have so far. The woman whose trial will never happen. I wonder if in Florida, if you're in limbo for, I don't know, for an X amount of years, they're just like, you know what, we'll just let you go. Because maybe that's what Sarah Boone is thinking. Maybe she's hoping that if she can possibly have all these issues with all these public defenders, she might complain like, oh, see, it's not me, it's the public defenders. I don't have proper representation. Y'all should just let me go. So her case management September 24th, which is, it's a long ways from now. Trial date set for October 7th, which means nothing to me at this point. We've had her trial date rescheduled over and over and over and over. It like means nothing to me. I feel like it's just a waste of space of the court's time scheduling these trials, and then it doesn't even happen. She obviously wants to have a bond hearing. She wants to be out on bond. She's on trial for murder. She said that she has fans. Maybe they'll make her a GoFundMe page, or I don't know if they made her a GoFundMe page, or that was her way of doing a PSA to everyone like, hey, fans out there, make me a GoFundMe page. Wink, wink, wink. Speedy trial. No. It's been like, what, 4 years since this happened? Happy Friday. Oh, is it Friday? Happy Friday, y'all. Oh boy, so that's it with Sarah Boone. I'll keep an eye out for the letter. Oh boy. Other than that, I'm sorry, my background's really messy right now. I'm actually gonna do a whole overhaul of my office space. I've just been lazy. I need to get a new camera. I need to do new background, and I might paint the walls because I feel like sometimes the white is a little bit too bright, but we'll see. And also, I think I want to get rid of this rug because I really like my wood floors that I have behind me. Maybe get like a smaller rug. All right, y'all. So let's switch gears. Let's go over to the cross-examination of Trooper Buchanan, Yuri Buchanan. I think there might be a little bit of direct examination with Mr. Lawley. We were talking about how the Sallyport may have been mirror flipped. I did do a screen grab and I flipped it. I posted in the community part of the YouTube. I don't know if it has importance or anything like that, but I feel like it would be important for Mr. Lawley because when the jury is viewing that Sallyport video, they're going to be like, oh, we can see the tail light that's supposed to have hit John O'Keefe and it's supposed to be busted. But when they're pulling the car in, it looks like it's working, maybe. It looks like it's lit. It looks like the red pieces are still there. So I don't know if it was just an oversight by Mr. Lawley or me giving him the benefit of the doubt. Maybe I didn't hear Mr. Lawley mention it, but I was watching other people's reaction to it. I watched Vinnie Politan's reaction to it. I watched Laura Uno's reaction to it. I think those two. Yeah. So I don't think I'm the only one that pointed out that Mr. Lawley didn't say that, oh, this is a mirror flipped image of the Sallyport. I don't know. I don't know what's going on with the Karen Reed trial. It's at least what's going on the state side. I don't fucking know. But if anything, I feel like it would have been more important for the state to point it out. Like, hey, by the way, this is mirror flipped. So we'll watch the cross-examination of Trooper Buchanan. It was a half day. And I think court actually ended like an hour or two early yesterday. I think by the time it was maybe like 9 or 10 my time, I think trial was already done for the day. So we won't have too much to catch up on. All right, y'all. Let's watch. Thanks for joining us for the Karen Reed trial. How is everyone doing, by the way? You guys have any plans for Friday? I've been on Facebook Marketplace buying a bunch of used furniture and lamps and stuff like that. Oh man, it's been pretty fun, but it's kind of time consuming. Hi, Sarah. Hello, my beautiful chatters. Y'all are beautiful too. Objection to Corey flipping the camera. At least the judge in the case didn't allow it to flip the video. You know, what if I flip you off right now? I'm just kidding. The judge has some work to do in the afternoon from the other cases. Yeah, I think that was mentioned. The reason why we're on this like very weird, odd cookie schedule is because she's got some other cases that she's working on. I don't know. Maybe she has a Sarah Boone in her life. It's messing up her schedule.
All persons have any business before the Honorable Henry Cannoli, Justice of the Norfolk Superior Court, in copy of the motion. Do I dare give your attendance?
Doing any independent research?
No, Judge. No independent research. Like I have been doing independent research on this case. I have been. I've got all these. I have a subscription to Scribed now. It's like a free month trial, so I have a bunch of Karen Reed stuff that I've been reading. It's lengthy.
Circle back just to a couple things.
Oh, you're going to Grace's high school graduation. Oh, fun. Well, have fun. I hope the weather's good. I remember, was it my high school graduation? Might have been mine. No, mine was indoors. Was it my brother's? I could have sworn I went to a high school graduation that was outdoors and it was like really fucking hot outside. Or am I just tripping? I hope it's indoors and I hope the weather's great. There you go. Hi,
Your
Jan.
testimony from yesterday. Going back to the video that you reviewed from both C.F. McCarthy's and the waterfall. In total, from those two videos, how many drinks did you observe the defendant consuming over her time?
The video shows 9 drinks being consumed by the defendant.
And that's between when she arrives at C.F. McCarthy's until the time that she leaves the waterfall, is that correct?
That is correct.
And if I could turn your attention to the ring videos from 1 Meadows Avenue, Mr. O'Keefe's residence. From the videos that you observed, let me ask you first, as far as, do you know how those cameras work as far as when they turn on and when they turn off?
My understanding is that ring surveillance video is triggered to be recorded through motion. So if the camera detects motion, which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system.
I will say though, when Steve died, I went through my my ring video to capture, because like it's only stored in your system for like X amount of time before they like dump it out. So when Steve died, I went through all my ring stuff and I screen recorded like anytime he popped up in the camera. There were times though where I'm like, no, we were definitely outside, but it didn't capture our motion and it didn't record. So I don't know where we're getting with this.
That retains that.
I just want to point that out.
Footage.
And from your review of those videos, what kind of motion would set those off? Like what kind of things would be recorded?
Who testified again? Because she completely, oh my God, I feel so bad. Her testimony, he is now forever known as Officer Bouquet. Was it Julie Albert? Oh God. I kind of feel bad for this officer because now his name is like forever like tainted.
From the driveway camera.
Be activity in the driveway, such as a person walking through, bird landing, a vehicle pulling in, individuals, moving around in the driveway, and so forth.
And the search warrant that was applied for was any and all videos between January 24th and January 30th, correct?
For one of the search warrants, that's correct, yes.
And with respect to that time frame, what, if any, activity?
Steve is my little corgi, my little doggo. I have Shiro's here, but Steve was my first little man.
Based on information that you had received.
No, it wasn't Jen McCabe. It was she was blonde. I think it was Jen McCabe's sister. She was the blonde lady. I think it was Julie Albert. I think Julie's married to Chris Albert, right? Nicole is married to Brian Albert. I think it was Julie Albert. I think Julie Albert was the one that said bukake. Because now when he testifies, that's what people are going to call him.
Was not available or was not shown on those ring videos.
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in.
Oh, okay. Sorry, I was a little bit distracted with the chat. Okay, let me get my notes up. Oh God, lots of distractions. Okay, so I did hear about this. They have ring footage of Karen Reed leaving 34 Fairview. They have ring footage of Karen Reed arriving 34 Fairview with Jen McCabe, with Carrie Roberts. However, they're saying that there's no ring footage of Karen Reed arriving after dropping John O'Keefe off at 34 Fairview. But I mean, this whole motion camera thing can go both ways, right? You know how like in the Sallyport, actually now I'm a little bit confused because I could have sworn people said that there was no Sallyport image of Karen Reed's car arriving, but we just saw a couple, I think it was like the day before this, that there is a video of her car arriving at the Sallyport. And I think there were people saying, they were like, oh, there's like times that are missing. And I was like, oh, because it could be just be like, sometimes when it's like motion activated, it could be a little bit fucky. So maybe motion activated was also fucky in this one too. Or I don't know if they can get into the ring camera database to see if like, oh, was it deleted or not? I don't know if they can do that, but maybe they can.
The data that was returned from ring.
What, if any, other video in addition to that one was not present?
There was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
Oh, that's where I was wondering why didn't this guy testify first? Hello? So I thought that the state was just being a little bit weird with that because Carrie Roberts, Jen McCabe was like, oh yeah, when we got to the John O'Keefe's house, pointing out the taillight, blah, blah, blah. And I'm like, I didn't see that. Why haven't they shown that yet? Why aren't they showing this? It's like so weird. Why are they dancing around this? Why not have him testify and lay all this stuff out? That way, when the other people testify, we could be like, oh, now we know why there's missing footage, Whatever.
And what, if any, follow-up or what, if any, inquiry was then done with regard to Ring as far as...
Oh, gotcha. The defense was told there was no video. Okay. Was that in pretrial stuff? I guess I can... I have some of the Karen Reed court documents. I will sift through for that. All right, so what day are we in? Day 21? Okay, continue direct your review. Buchanan.
Those types of videos or deletion or how those videos could not be present.
Correspondence with Ring produced information that...
Sustain.
Oh, man. Do they have people from Ring that can come up and testify about this? Also, when did they get their hands on the Ring footage?
Let me ask this first. Was there follow-up with Ring in regard to those videos?
Yes, there was.
And was there ever anything produced with regard to those videos or those time frames from Ring?
No, there was not.
If I could turn your attention over to your time in Dayton, just in reference to subsequent to that later on, what, if anything, did you receive, or what, if anything, did you request, what, if anything, did you receive from the Dayton police in regard to January 29, 2022?
I communicated with the Dayton Police Department requesting documentation from their officers' calls for service at our request and log notes.
Mm-hmm. Yeah, I agree with that, E. Camera detecting can be proved, but camera not detecting might be error, and I wouldn't count it as evidence. Yeah, 'cause sometimes technology could be a little bit finicky sometimes. For me, it would be like, if I was a jury, I'd be like, okay, well, that's weird that there's no footage of her arriving, or there's no footage of, her showing Carrie Roberts and Jen McCabe, the busted taillight, whatever, right? However, it'd be one of those things where it's like, okay, it's like here, document in my head. It's weird, but that's about it. I would need to hear from someone from Ring or whatever expert that tells me that, like, oh, here's this and this and this. Here it shows that it was deleted. It was deleted by this person. It was deleted this time. Blah blah blah. Like, I would need to see that, because sometimes technology could be weird. Because like I said, when I was looking for footages of me and Steve on the front yard, there were times where my Ring camera didn't capture the motion. I'm like, no, I definitely took him out to go pee like 3 times a day, and like sometimes it didn't record that.
Logs from their dispatching center, as well as any reports that would document their activity if such reports existed.
And
oh my God, Warden, I read that as like, I thought you had 3 Porsches. I was like, wait, 3 Porsches? Hold on a second. What are you doing? What are you doing over there?
What, if any, information did you receive in relation to that?
I received a log note or log printout from their activity for service at our request.
29, 2022.
Sorry.
I communicated with the Dayton Police Department requesting documentation from their officers' calls for service at our request and log notes, logs from their dispatching center, as well as any reports that would document their activity if such reports existed.
And what, if any, information did you receive in relation to that?
I received a log note or log printout from their CAD system, and I received a report authored by Officer Barrows.
And did you also receive any 911 calls?
Yes.
And who was the party as far as the 911 caller in regard
Oh, is this when her dad called because he was concerned about Karen Reed?
to those 911 calls that you received?
It was Mr. Reed.
And again, just for clarity purposes, that's the defendant's father, is that correct?
That is correct.
And that's from the morning of January 29th, is that also correct?
Correct.
Now, sir, if I could turn your attention to February 3rd, 2022. At some point that morning, where did you go?
During the morning hours of February 3rd, we planned.
Hold on, let me do this instead. Give me a second. I like having the transcripts up side by side. That way, if I miss anything, I don't have to keep rewinding it and then annoying you guys. I'll just like scroll up in the transcripts instead. Sometimes, I don't know. I wish I should go back to typing class. I want to type faster.
And to meet at 34 Fairview Road. Myself, Trooper Proctor, and Trooper DeChico arrived at that location in order to conduct a secondary search of the area as the temperatures were turning and the snow was melting naturally. We decided to do another search for articles that were now, we realized and learned, were missing and could be of evidentiary value and aid in the, in the investigation.
And with respect to going to 34 Fairview Road, what, if any, tools or what, if anything, did you bring with you, you and the other troopers, in regard to conducting that secondary search?
I requested the troopers bring shovels, rakes, anything like gardening items that would help them to dig through the snow.
Leaf blower, also a gardening item.
And locate any missing items.
And as far as the temperature change that you're talking about, how precipitous a change are we talking about?
The temperatures went above freezing, so the snow did begin to melt, and it was significantly warmer compared to the 18 degrees the night of the incident.
Now, you mentioned items of evidentiary value that you had learned of and were looking for. What, if any, clothing items, Mr. O'Keefe, were you looking for specifically on February 3rd?
We were specifically looking for Mr. O'Keefe's baseball cap.
And in addition to yourself, Trooper Proctor and Trooper DeChico, who, if anyone,
Oh, yeah, he was wearing a baseball cap.
else did you notify, or who, if anyone, from any other unit within the state police responded that day as well?
We requested the assistance of the Crime Scene Services section of the Massachusetts State Police, and Trooper Evan Brent showed up to assist us with documentation of the location and the evidence that we were hopefully going to find.
And from those, Trooper Brent arrived and took photographs, is that correct?
That's correct.
And when was it that Trooper Brent arrived in relation to your arrival?
I believe he was already present when we pulled up, but I'm not sure to his exact time of arrival.
And with regard to that day, what, if anything, in general terms, what, if anything, were you able to locate, and where was it, generally speaking?
We located Mr. O'Keefe's baseball hat. We located a drinking straw from a cocktail glass. We located items of plastic, colored plastic, and other shards of colored plastic at the location. All those items were located on the grass portion of the yard near the flagpole at 34 Fairview Road.
And Your Honor, may I please?
Yes.
Your Honor, may I have a moment?
Yes.
Break.
So, Mr. Lally, with your...
Mr. Lally, she can't hear you. You need to speak up a little bit.
Finished.
It's kind of like Judge Penny telling Elaine, turn on your microphone. But that's way worse.
Those, sir?
Yes, I do.
And what do you recognize those to be?
Those are photographs documented the items located at 34 Fairview Road on the grass as the snow receded through the melting temperatures that were revealed to be positioned in the grass.
And what's contained in those photographs, is that a fair and accurate portrayal of what you observed on the front lawn area of 34 Fairview Road on February 3rd?
Yes, it is.
Your Honor, may I approach?
Yes.
I'm also seeking to do some minutes next to
Any objection, Mr. Jackson?
publish some of these photos.
Yes.
And Ms. Gilman, if I could start with photograph 7659. And Sergeant, do you recognize what's up on the screen, what's now been marked as Exhibit 468?
I do.
And if you could, just for orientation purposes, describe the jury whereabouts in relation to 34 Fairview
Oh, hey, what's up, Maureen? How are you doing today? Seems like the leaf blower was left at home.
Road. We are in this picture.
As standing on the street of Fairview Road, we're looking at the left side of the yard. In the top right corner, you can tell that there is a flagpole depicted in that photograph and a telephone switch box that's open on the left side, which is on the border of 34 Fairview Road.
If I can ask from this photograph, if you know, grass that's visible on the front lawn area of 34 Fairview Road, is that from a natural melting process, or is that from some tools that you and the other troopers brought to assist you in your secondary search?
The reason that graph
Where are all these pictures? They look so eerie. It's as if it's from a horror movie.
is exposed is due to processing of the scene and having the snow being moved away from the location, and then natural melting process taking place on top of it. As you can tell, other portions of the yard is covered in snow, and the snow had not, the grass has not revealed itself just yet.
Now, as far as the photographs of various items that were located on this date, February 3rd, the photographs that were they taken as they lay, or were they touched or manipulated in any way prior to the photograph being taken?
The items photographed were discovered as soon as we realized what is being discovered through the digging and excavation process. They were then photographed instantly. Certain items were revealed naturally through the melting process and the snow, no longer concealing those items underneath.
Thank you. Ms. Gilman, can I photograph 7666?
You?
What do you recognize that?
That is a clear black and red piece of plastic.
And Ms. Gilman, if I can have photograph 7669. And Sergeant, do you recognize what's now on the screen as Exhibit 473?
Yes, that is another piece of plastic.
And sort of towards the top middle of the screen, do you recognize what that is?
Yes,
Where? Right here? I can't really see.
that's a fire hydrant from 34 Fairview Road, grass area.
Ms. Gilman, if I can have the next photograph, 4670. For the record, this is Exhibit 474. Do you recognize that, sir?
Yes, sir.
Is that a closer-up image of what was depicted in the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7672. And, sir, do you recognize what's on the screen, which has now been marked as Exhibit 476?
I do.
And what do you recognize that to be?
Another piece of red taillight plastic.
And lastly, from dispatch, Ms. Gilman, if I could have photograph 7673. Again, sir, do you recognize what's up on the screen, depicted in what's now marked as Exhibit 477?
I do.
What do you recognize that?
That is the fire hydrant and the telephone switch box located on the edge of the property line at 34 Fairview Road.
Now, the photographs that I had just placed before you, have you had a chance to review those?
I have.
And do you recognize what's depicted in those photographs?
I do.
And what do you recognize those?
The property at 34 Fairview Road, left corner towards the street, capturing the flagpole and the telephone switch box.
May I approach on? Your Honor, with the court, if I can publish a few of them. Ms. Gilman, if I can have photograph 7 from this set.
Okay.
Ms. Gilman, if I can have photograph 7681. The screen has now been marked as Exhibit 481.
I do.
If you could describe to the jury what's depicted in this photograph.
A red piece of plastic.
And Ms. Gilman, if I can have the next one, 760.
Where's the laser pointer?
Can you use the pointer to show us where that is,
Yes, please. Thank you, Judge.
please?
Yes, Your Honor.
I'm like, where?
All right, thank you.
Because there's like leaves everywhere. They're all the same tones and shades.
And Sergeant, do you recognize what's depicted on the screen has now been marked as Exhibit 482?
I do.
You know, I'm going to see counsel at sidebar for just a minute, please.
I'm sorry. And Sergeant, do you recognize what's up on the screen as Exhibit 482?
I do.
What do you recognize that to be? Is
A red piece of plastic.
that the same piece of plastic that closer-up image from the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7684. Sergeant, do you recognize what's up on the screen and is now been marked as Exhibit 484?
I do.
And what do you recognize that to be?
A white clear piece of plastic and a red piece of plastic.
And lastly, from this, sir, Ms. Gilman, if I could have 7687. Sir, again, do you recognize what's up on the screen? It's now been marked as Exhibit 487.
I do.
Now, Sergeant, with reference to the photos before you, have you had a chance to review that set of 10 as well?
Not this one yet, not yet.
If you could, please. And Sergeant, do you recognize what's depicted in those photographs?
I do.
What do you recognize those to be?
Items that were located in the street, being the black cocktail drinking straw, and then black pieces of plastic, molding plastic, and clear pieces and molding from taillight.
May I approach, Your Honor?
Yes.
I'm up to introduce the minutes next time, sir.
Any objection, Mr. Jackson?
None, Your Honor. Thank you. Your Honor, with the court's permission, if I could, these photographs. And Sergeant, do you recognize what's up on the screen?
I do.
What do you
Straw?
recognize it to be?
It's the wide shot of the drinking straw being found on the edge of the roadway in front of 34 Fairview Road.
Sergeant, if you could, using the laser pointer before you, if you could direct the jury's attention to where you observed that straw. And Ms. Gilman, if I could have 7689. Sergeant, what are we looking at in this photograph?
It's a close-up view of the same straw.
Did they DNA test it?
Ms. Gilman, if I could have 7692. Sergeant, do you recognize what's up on the screen? It has now been marked as Exhibit 492.
I do.
And what are we looking at in 492?
Piece of plastic next to a measuring ruler that's provided for comparison and by the crime scene photographer to document
Yeah, I was like, why was there not a ruler in the other picture?
the item.
And this gentleman, if I could have 7695. For the record, this is now Exhibit 494. Sergeant, what are we looking at in 494?
It's the same item from just prior, just zoomed in more, showing the detail, the black molding, the clear clear plastic, and red plastic.
Sergeant, as far as those photographs before you, have you had a chance to review those?
Yes, I have.
And do you recognize what those are?
Yes, I do.
What do you recognize those?
They're pieces of...
We're still wondering if the hair found on the back bumper, if it's DNA, if the DNA matches John O'Keefe or not.
red plastic, pieces of clear plastic, and a piece of glass.
May I approach, Your Honor?
Yes.
I'm about to seek to introduce the minutes next sentence. Okay.
Thank you.
Thank you very much. Your Honor, with the court's permission, if I could publish just a few of these photographs for the jury. In photograph 7700, for the record, this is now Exhibit 498. Sergeant, if you could describe to the jury what we're looking at here.
We're looking at a red piece of plastic next to a measuring ruler on the edge of the grass on the property at 34 Fairview Road by the road.
And if you could, sir, using that laser pointer, just direct the jury's attention to where you observe that item to be in this photograph.
Right there.
This gentleman, if I could have photograph 7705.
I'm sure law enforcement, I'm sure as hell that they are traumatized by this case, that from now on, they will try to be as fucking more thorough as possible.
And for the record, this is Exhibit 502. And Sergeant, if you could, again, describe to the jury what, if anything, of significance you noted in there.
It's a shard of red plastic next to a measuring ruler.
This gentleman, if I could have photograph 7708.
Oh, Andrea Burkhardt brought this up. When the two troopers arrived at Karen Reed's father's house, she was wondering, why didn't they take pictures of the car right away? I mean, everyone has their cell phones on them, right? It's like, if you see the tail light is busted, why not take a picture of it? Why not take a picture of it and then bring it all the way to Cannon PD and then wait till then? Like, I don't know. I feel like we would just take a picture of it right away, just in case. Just
The
more
record is now
thorough.
Exhibit 504. Again, Sergeant, if you could, using a laser pointer, direct the jury's attention to what, if anything, of significance you note in this area.
There is a black piece of plastic molding next to a measuring ruler.
And lastly, from this set, this gentleman exhibits, photo number 7712. Again, for the record, this is Exhibit 508. And again, Sergeant, if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you note in this.
A clear piece of plastic next to a measuring ruler.
That's found on the grass area as well, is that correct?
That is correct.
Now, Sergeant, with reference to that new set of photos before you, have you had a chance to review those?
Yes, I have.
And do you recognize what's contained within those photographs?
Yes, I do.
And what do you recognize that those photographs to contain?
They contain small red pieces of plastic from 34 Fairview Road on the grass area where we located the others. Also contain a flimsy piece of circular, like very malleable plastic, clear plastic, in addition to that.
Oh, wait. Circular piece. Wait, circular piece of plastic? Are we getting there?
And malleable circular.
Oh, this one right here.
For the record, this is now Exhibit 511. Sergeant, direct your attention to the screen if you could, using that laser pointer, direct the jury's attention to what, if anything, of significance you observe in this photograph.
That is the thin, malleable, circular in shape, a piece of clear plastic that was located in the lawn area of 34 Fairview Road.
Wait, because you know how they did the reconstruction? The red pieces were put back, but then there was like still that like chunkling of clear piece that was not put back. Is that it, or is this something else? What the fuck is this?
Now, lastly, Sergeant, there's that set of photos that I just placed before you.
Oh, no.
Yeah, you had a chance to review.
No,
Now, lastly, Sergeant. Now, lastly, Sergeant, there's that set of photos that I just placed before you. Yeah, you had a chance to review those.
Yes, I have.
And do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those to be?
There are items. Those are items recovered in the lawn at 34 Fairview Road. Those items are a shard of glass, a BPD baseball hat with an American flag, and stains of blood.
Madam Mayor, approach.
Yes.
No, they got the
I'll
hat.
introduce the next. Sorry. Okay.
Five what?
These photos of jury as well.
Yes.
For the record, this is now Exhibit 520. And again, Sergeant, if you could direct the jury's attention to what, if anything, of significance you observe in this photograph.
I observed a shard of glass next to a measuring ruler.
And the family, if I could have 7729.
Lolly believes that John O'Keefe was hit twice. he hasn't explained to us yet really how all this connects. Because what I would like to see, I'm sure it will be later on, or it better be later on. I would like to hear from an expert that would kind of compare how John O'Keefe was hit and then how the injuries would all line up, like the scratches and all that stuff, right? Maybe he'll get there. Maybe not. I don't know. I don't have a lot of high hopes for this. But Lolly thinks that John O'Keefe was hit once, and then while he was down, he was hit a second time. That's what the state said.
For the record, this is Exhibit 522. And again, Sergeant, if you could scrap the jury a little again.
It's a larger piece of red plastic with black molding around the edge, located next to the telephone switch box on the grass area at 34 Fairview Road.
And this gentleman, if I can have photograph 7733.
He better.
If anything, we're looking at here.
We'll see.
This photograph here depicts the area which we are excavating during the morning hours of February 3rd, 2022. As the shovel works its way towards the grass, my laser pointer is directing your attention to Mr. O'Keefe's hat that was compacted underneath the snow on the ground.
Now, as far as this photograph is concerned, does that accurately depict the depth of the snow that you were digging into and sifting through on the morning of February 3rd?
It does.
And that, again, is several days after the blizzard of January 29th, correct?
That is correct.
And this gentleman, if I can have photograph 7740. You could describe to the jury what we're looking at here.
Oh, the hat.
We're looking at Mr. O'Keefe's hat on the grass, pressed down and compacted to a flat surface underneath the snow, which has been excavated around it.
Thank you very much. Ms. Gilman, you can take that down.
Yeah, so what I wanted to see was once they picked up the hat, once they picked up the shoe that was found, was there any snow underneath it? Was there grass underneath it? That's what I wanted to see.
Thank you, Mr. Ross. Thanks, Jim. Sergeant, on February 3rd, 2022, is that the first time that you had been at 34 Fairview Road?
Yes, it is.
And with respect, if I could turn your attention briefly to the following day of February 4th, did you have occasion to go back to 34 Fairview Road on that day?
Yes, I did.
And what brought you to 34 Fairview Road on February 4th?
Having excavated those items on the 3rd, I directed the troopers in my office, who obviously reside in the communities around us, to make a point to travel by that location every day on the way to work and every day on the way home. The purpose of that was to see if anything else was to reveal itself as the snow naturally melts away and items could present themselves. So on the February 4th, as I am traveling to work, I diverted my typical route of travel to go by 34 Fairview Road. Just prior to my arrival, I received a call stating that there was
Hey, Bobby, how's it going?
Kent police representatives at the scene, and more items have been revealed due to the melting snow, and that I should come collect those items. I was down the street. I arrived and collected the item that presented itself.
And if you recall, that item that you collected on February 4th, was that located on the lawn, on the street, or something else?
It was on the lawn.
Now, with reference to your collection of these items, either on February 3rd, February 4th, or on any sort of subsequent date, how were they collected, and what exactly did you do with them in reference to the seizing of the items and storage of the items?
Each item that was collected was placed in an evidence paper bag. The collection was done by utilizing latex gloves to prevent any transfer of evidence from fingerprints to DNA onto those items. Then those items were transported to our office, logged into the system, and stored in the evidence lock.
Did we get any clues on whether or not Proctor is going to testify?
At the office.
In each of those respective bags of items or evidence, they were sealed as well, is that correct?
That's correct.
Now, turning your attention to February 10th of 2022, did you have occasion to go back to 34 Fairview Road on that day as well?
I did.
And what, if anything, did you observe, or what, if anything, did you seize on that particular day?
We seized more shards of glass and plastic.
And if you know, or if you recall, how many pieces did you seize on that particular day?
My memory is exhausted to that, but the exact numbers annotated on the bags that the items were placed into.
You want to approach?
Yes.
I'm showing you documents attached to look at that section and look up on it. May I approach?
Yes.
Refresh as to how many items or what the items were that you recovered on February 10th?
Yes, it is.
And what were those items and how many, sir?
There was 6 items of clear red and black plastic and 14 items of plastic and glass.
Now, in addition to the dates that you were present at 34 Fairview Road and recovered items, them being February 3rd, February 4th, and February 10th, were there other dates that you're aware of that items were recovered by troopers that you supervised?
Yes.
And if you recall, what were those dates?
The dates were January 29th, February 11th, and February 18th.
Were there items recovered on February 8th as well?
Yes.
Now, as far as your direction or having Let me first start with you. So on the dates that you were there, February 3rd, 4th, and 10th, were you alone on those dates? Were there other troopers with you when you were there?
On the 4th, I was alone as far as state police personnel. There were other Canton law enforcement representatives at the scene with me as I collected that one item. On the other days, I was accompanied by other troopers.
And as far as you know, obviously not being present, but from your supervision of these troopers, were there other occasions where individuals were at 34 Fairview Road? Were they alone or were they with a group of troopers?
Objection.
Sustained.
Now, as far as the items that were recovered when you were there on February 3rd, February 4th, and February 10th, did you have occasion to bring those items with you to court today?
Yes, I did.
Your Honor, may I approach?
Yes.
I'm presenting you with a box. First, just ask if you recognize that box.
I do.
And what do you recognize that?
It's the box storing items logged into evidence as they relate to this case.
And, Your Honor, with court's permission, may the sergeant open the box?
Yes.
Excuse me.
Now, First Sergeant, with regard to the items as far as plastic and/or glass that you recovered from 34 Fairview Road on February 3rd, if you could locate those items. Plastic or glass.
I have plastic and clear.
Introduce in a minute. That item.
All right, so they're gonna go through. I know right, what's in the box. They're gonna go through all the pieces.
Sergeant, from your observations of Mr. O'Keefe on surveillance video from both C.F. McCarthy's and the waterfall on January 29th, what, if any, similarities did you observe between the hat she just displayed and located on the lawn of 34 Fairview Road and the hat Mr. O'Keefe is wearing in those videos?
It appears to be the same exact hat.
Now, Sergeant, with reference to the box of other items, if you could remove what, if any, items you recovered and seized from 34 Fairview Road on February.
This guy sounds like a jerk trying to sound smart using big words. He just talked normal. I have no qualms with this guy. My issue is with list. My issue is with Mr. Lawley. When Mr. Lawley was trying to get this guy's perspective on John O'Keefe's injury, and I was like, Lawley, what are you doing? Where the fuck is the medical examiner? I don't know. That rubbed me the wrong way.
Right, 4th. And again, sir, just for the record, what's contained within that bag from February 4th?
Contained within the bag is a piece of red, hard plastic taillight cover.
Your Honor, I'll seek to introduce in a minute the next exhibit.
Objection.
Hey, Thomas.
And lastly, Sergeant, with regard to the box, if you could remove the items that you seized from February 10th, 2020.
If you quit and retired, do you still have to testify?
And Sergeant, with respect to those two bags of items, if you could just inform the jury what is contained within those bags.
Bag labeled item number 10 contains 6 pieces of red, black, and clear plastic. Bag labeled number 11 is containing 14 pieces of glass and plastic fragments.
Thank you, Sergeant. Your Honor, I'll seek to introduce and admit as the next two exhibits.
Any objection, Mr. Jackson?
Sorry, no, Your Honor, thank you.
Nope.
I'm sorry, was that 559?
Moving on from that, if I could bring you back just one last time to the ring videos from One Meadows Ave, as far as you had testified earlier that there was no video that you observed of the defendant, Ms. McCabe, and Ms. Roberts looking at the passenger side taillight area of the vehicle, correct?
That's correct.
Was there any video of the defendant, Ms. McCabe, and Ms. Roberts actually leaving from One Meadows Ave on that morning of January 29th?
There was not.
Now, as far as the videos that...
Wait, so there's no video of them leaving One Meadows Avenue? Oh, because I think maybe she showed them the taillight when they were leaving. I mean, honestly, I don't know when the taillight was shown because I think it got mixed up. I think some people said that it was like when they got there, and then some people were like, oh, maybe it was after when we left, or it was before we left. So it seems like they're not really sure the timeline of that one.
We're not there, as far as the defendant, Ms. McCabe, Ms. Roberts leaving. The next video depicted Mr. Camerano arriving at the residence to pick up Ms. Fergus, correct?
Yes, that's correct.
And with regard to the missing video of the defendant arriving at One Meadows Ave on January 29th, sometime after midnight, the video immediately preceding that, again, would have been Mr. Camerano arriving and picking up his daughter from One Meadows Avenue sometime around 11:30 p.m., correct?
That's correct.
Also,
those videos were both...
I went back to John O'Keefe's brother's testimony. Remember how we saw John O'Keefe's brother kind of like Karen Reed's car arrive, her dad's car arrive, and he was like helping. Or no, I think her car was her car already there? I don't remember. And he was like helping dusting off the snow. I guess maybe the brother didn't see whether or not the taillight was busted or not, because that wasn't asked.
Present, correct?
That's correct.
If I could bring you back to February 3rd, 2022.
But maybe he didn't notice it because it was mentioned that snow may have been caked on the taillight.
On that date, did you have occasion to meet with a gentleman by the name of Brian Higgins?
Yes, I did.
And when you met with Mr. Higgins, who, if anyone from your office was with you when you met?
Trooper Mike Proctor was from my office present during that interview.
And during the course of that interview, what, if any, documentation did Mr. Higgins provide you with?
Mr. Higgins provided me with a printout of a Sallyport extraction containing conversations via text message between him and Mr. John O'Keefe and between him and the defendant. He also provided a digital copy of the same extraction on a CD.
Now, what, if anything, did you advise Mr. Higgins of at that time as far as Mr. O'Keefe's phone and the defendant's phone?
I advised Mr. Higgins that we were in possession of both of those devices and would have the extraction and accurate documentation of those conversations.
And did he seem to understand that when you told him?
Yes, he understood it.
Objection.
Sustained.
Move to strike.
Strike that, folks.
Now, also on February 3rd, at some point, did you have occasion to go inside of 34 Fairview Road?
Yes, I did.
And who, if anyone, did you interview inside of 34 Fairview Road on that day?
I interviewed Mrs. Albert.
That would be, just for the record, Nicole Albert, is that correct?
That's correct.
And who, if anyone, was present with you during that interview with Nicole Albert?
It was Trooper Mike Proctor was present with me.
Anybody else from the Albert family present in the home or present during the course of that interview?
Mr. Brian Albert was also present. I don't know who else exactly was present in the home. I just know that those two residents were in the room with us.
And where was Brian Albert at the time that you conducted the interview with Nicole Albert?
In the room with us, seated next to her.
Now, with reference to...
It's so crazy to me that, I mean, okay, they don't wear body cam, but isn't it good to, I feel like it's so good to record interviews.
I'm going to ask you just a little bit about sort of the interview process as far as the interviews that you conducted in this case.
Yes.
If you could describe for the jury, starting with sort of how many people from your unit are present for a given interview and how those interviews are conducted.
We conduct interviews always at pairs. I think I mentioned it yesterday. Typically, during a regular investigation into a homicide or any death investigation, we pair up our troopers with a local detective. In this instance, since Canton had recused themselves from interview portion of the investigation, they were not going to provide manpower for those interviews to be conducted. Thus, we had to utilize only troopers from our office in order to conduct those interviews.
And typically, obviously not perfect, but as far as the interviews that you were present for, about how long a period of time, generally speaking, were the interviews that you conducted in this case?
From my experience, I have learned that to fully communicate a course of recollection of events that an individual observes, experiences, or is aware of, and understand every detail of that experience, it would take approximately 45 minutes at a minimum to conduct a full interview with a witness in detail.
Now, sir, if I could turn your attention to...
I don't know. Someone in my chat mentioned, I don't know if it's true or not, but they mentioned that they didn't have body cam footages back then, but apparently Canton does have body cam now, which I hope they do.
June 9th of 2022. On that date, at some point, did you have occasion to meet with the defendant?
Yes, I did.
And at some point...
Also, what I'm curious about was, did they take contemporaneous notes? So let's say there's no body cam footage, no recording, whatever. Did they take notes? And then did they write like a write-up report after meeting with these people for interviews?
In that meeting, did you have conversation with the defendant?
Yes, I did.
And was that conversation, or at least portions of it, memorialized in any way?
Oh!
Yes, it was.
Your Honor, may I
How?
approach?
Yes.
I'm showing you a disc. Does that contain an audio recording, to the best of your knowledge? Does that contain an audio recording of a portion of your conversation with Ms. Reed on June 9th, 2022?
Do we get to listen to it?
Yes, it does.
Your Honor, may I approach?
Yes.
I'll also seek to introduce the minutes of this exhibit.
All right. No objection, Mr. Jackson? All right, folks, before we play this, again, please be mindful of the instruction from yesterday. So you're about to hear statements allegedly made by the defendant, allegedly concerning the crimes with which she's charged in this case. Before you can consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether the statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or any questioning by the police, the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor, and you must consider the totality of the surrounding circumstances.
So I listened to her TV interview.
Your Honor, with the court's permission, may we publish that for the jury at the time?
Yes, do you want to turn off the air conditioning? Is this very short, right?
It is very short, and if we could, please.
Oh, it's very short. Oh, is it just her saying that, like, oh, I want to have I don't want to talk to you guys without my lawyer present or something like that? You have substance.
On hearing that statement from the defendant, what was your reaction? Objection.
Sustained. And this is just audio, correct?
Wait, let me slow it down.
Okay, you're aware that you speeded up the brand conference.
I can't hear shit. Am I a Capricorn? No, I'm not a Capricorn. Ooh, I'm a saggy tits Sagittarius. I can't hear shit. Can y'all hear anything? Yes, I'm a very skeptical person.
Okay, you're aware that you speeded up the brand conference. I mean, we're all in on the same joke, right? My tail is correct and John was pulverized.
We're all in the same joke, right? My tail lights cracked and pulverized?
Thank you. Now, Sergeant,
Oh, God. Does anyone know what she said in the beginning?
Okay, you're aware that you speeded up the brand conference. I mean, we're all in on the same joke, right?
Oh, she says, you're aware that he was beaten by Colin and Brian Albert. We're all in the same joke, right?
My tail is correct and John was pulverized.
My taillight's cracked and John's just pulverized. Why did they play this? To get ahead of it?
action.
Objection.
Sustained.
On hearing that statement, what, if anything, did you do?
I advised the defendant not to further speak.
Objection.
I'll allow that.
Now, at some point over the course of your investigation, were you made aware of forensic findings relating to the defendant's tail?
Yes, I was.
And specifically DNA findings?
Yes.
And specifically that there were...
Objection.
Sustained.
So I'm going to go back real quick because I want to get exactly what she said. One last time. One last time.
At some point over the course of your investigation, were you made aware of...
Okay, you're aware that you speeded up the brand conference.
I wonder, so by June 9, oh, this is like about 6 months afterwards. Why Colin Albert, I guess? Because Colin was never, Colin wasn't at the waterfall. So I wonder what tipped her off that she thinks it was Colin Albert that did it.
I mean, we're all in on the same joke, right? My tail is correct and John was pulverized.
Hey.
Okay, I wish we had the entirety of the conversation. Whatever.
At some point over the course of your investigation, were you made aware of forensic findings relating to the defendant's tail?
Yes, I was.
And specifically DNA findings?
Yes.
And specifically that there were...
Objection.
Sustained.
Oh gosh, we want to hear this. Just
Yes.
kidding. Sustained.
Go back. Have one moment.
Yes.
Because usually, let's say they play something to get ahead of it, Lolly will work with the witness to explain how this benefits them, right? But that was a sustained. I don't know. Maybe it was getting there. Didn't help.
So, Sergeant Mechanic, on January 16th, 2024, at some point in that day, did you meet with a Sergeant Gallerani of the Needham Police Department?
I did.
And
Someone in the house? Who?
who, if anyone else, well, let me ask you this. As far as any other troopers from your office, who, if anyone else, was there with yourself and Sergeant Gallerani?
Trooper Mike Proctor.
And what was the purpose of your meeting with Sergeant Gallerani and Trooper Proctor on that morning?
Collection of our DNA.
And was that something that you did voluntarily?
Yes.
And how was it that the sergeant collected your DNA?
Through a buccal swab.
And were you present when Trooper Proctor submitted to a buccal swab as well?
Yes, I was.
And then as far as the swabbings that were taken from both yourself and Trooper Proctor, were those logged into evidence by you, or did Sergeant Gallerani take them with him when he left?
Sergeant Gallerani took him with it when he left.
My apologies, Your Honor.
That's okay.
Thank you very much, Sergeant. Your Honor, I have no further questions.
Oh, gosh. Oh boy. I'm going to use the restroom really quick. Hi, Legotron. What's up? How are you doing today? The defense used this, but I don't take it as it has, but I don't take it as the defense presented. I hear it more like she found ridiculous what the, okay, I don't know what to say. I don't know what that says. The defendant with the face tattoos? Who? You forgot his name, but he's recent? What's the case about? And wash my hands. Okay, we're doing cross-examination. Okay. State trooper. Cross-examination. Florida accused of offing 2 people. I don't think I've heard about it. When's their trial supposed to be? There's one where this man is accused of murdering his wife. That looked a bit interesting.
Okay. Cross-examination?
Thank you, Your Honor. Sergeant Butnick, I want to start with one of the latter things that you discussed with Mr. Lally, and that's specific to the ring video that y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video or series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper.
Oh, sorry. I was responding back to something. Oh, geez. How far back are we?
One of the latter things that you discussed with Mr. Lally, that's specific to the ring video that y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video.
And I think this is what a good attorney does. They choose what resonated with the jury most recently, and they'll address that first. Mr. Lally doesn't do that. Mr. Lally's like, okay, let's go all the way back to the very beginning of my notes, and then we'll address each one. I think it's a good way to, Because the jury's minds are thinking about like, oh, there's a missing ring camera footage. Oh, that's kind of weird. And so when Mr. Jackson goes up there, he's going to address it right away. Lolly doesn't do that. I think Lolly needs to fucking do that. I don't know why he doesn't do that.
There were a series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper Mike Proctor received it.
And who ultimately either logged those into evidence or controlled those once they were received from the Ring Corporation?
I believe it was Trooper Mike Proctor.
And ultimately, Sergeant Buchnick, you did note that in addition to just the physical videos themselves, that login information and login keystrokes, et cetera, were requested from the Ring Corporation as well, correct?
There was discussion with Ring asking for those logs.
I'll call it, is it correct to say an activity log?
That's what was requested, yes, activity log, yes.
So ultimately, the activity log would show who logs in, who accesses the data, things of that nature, correct? Or at least that was the hope.
That is what was requested.
All right. It would also show logging in and executing deletions, manipulating the log files, things of that nature, correct?
That is what was requested, yes.
When you reviewed those log or activity logs, there was no evidence revealed that my client ever logged into that account, correct?
There was no activity logs provided by Ring.
So you have zero, hang on.
Did they ask for it? So they requested it, but they didn't get it?
Isn't it true that Ring contacted Trooper Proctor and indicated that they had created a Dropbox folder that contained the evidence that had been sought in the search warrant?
Objection.
Sustained.
Isn't it true that the search warrant returned specified account information, video recordings, and number 3, activity logs associated with video recordings for all times displayed in UTC?
I'm not aware of that, no.
Do you recall
He's like, you had to ask Proctor for that.
that video activity logs were in fact provided from the Ring Corporation?
I do not recall that, no.
Okay. May I approach briefly?
Yes.
Review.
No, that's a different guy. The TikToker that killed his wife and the other guy, right? No, that's a different one. This guy has like a swastika on his face. I would remember that, but no, I don't think I've seen that case yet.
Refresh my recollection, I simply read it.
So do you have a recollection, as you sit here, that in fact during the course of your investigation, the 3 items that you received from the Ring Corporation were the account information, the video recordings, and, quote, activity logs associated with the video recordings?
Oh, man. Do we not have anyone from Ring to testify? Oh, yeah.
Displayed in UTC.
To the extent of its availability, as it says in that document.
Okay. The long and short of it is, during the entire course of your investigation, you never revealed that investigation never revealed any evidence whatsoever that my client ever even accessed the account information for the Ring account associated with the search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
Thank you. Trooper Proctor, you were notified.
I'm not Trooper Proctor.
I'm sorry.
He's like, please don't call me Trooper Proctor. I'd rather go with Bukake than Proctor.
No, you're not. Sergeant Buchnick.
Sergeant Buchanan.
How do I say it?
Buchanan.
I'll give that a shot.
It's fine.
Buchanan?
Yes.
Is that better?
That's better. Thank you.
If I screwed up again, please. On January 29th, you were notified about a Boston police officer found gravely injured outside the home of 34 Fairview at about 6:40 in the morning. Was that your testimony?
That is not.
What time were you notified?
I was not notified it was a Boston police officer.
So you didn't have that information upon the first notification?
I did not.
Okay, what information did you have?
There was a male party in the snowbank, possibly of a heart attack.
At what point did you learn that the individual was, in fact, a sworn Boston police officer?
I do not know exactly when I learned that he was a Boston police officer.
I think it was during that day or the following day?
It was most likely that day, either. Yeah.
Fair enough. Trooper Proctor was ultimately assigned as the, what did you call him, not lead investigator, but case officer?
That's correct.
He was assigned on the 29th, correct?
He was on call from 7 a.m. on January 28th until 7 a.m. on January 29th.
So his assignment was, he was assigned on the 29th because he was on call.
He was on call. His assignment took effect when the schedule came out back in mid-December.
Okay. Well, he wouldn't be assigned to this investigation until there was a need for the investigation, right? That's all I'm getting to. I mean, once the call came in, he was the assigned, basically.
Once the calls come in, the person that's on call is automatically assigned that case.
All right. Did you personally, as his supervisor, did you personally respond to 34 Fairview at any point on January 29th?
No, I did not.
Did Trooper Proctor, at your direction or on his own, ever respond to 34 Fairview Road at any time on January 29th?
No, he did not.
Based on your initial investigation, and I'm talking about going way back, Sergeant, on your initial investigation, by 10 or 10:30 in the morning, 10:40 in the morning, it was your belief that Mr. O'Keefe had been struck in the face by a person. That was your initial understanding of the circumstances surrounding the investigation, correct?
My initial understanding was that the defendant stated that she hit him. We did not know them.
Sergeant, you hadn't even met my client at that point. You hadn't interviewed a single witness by 10:41 in the morning, correct? Not one witness.
That's not correct. We had already interviewed the first responders.
Okay, when I say witness, I'm talking about civilian witnesses. So 10:41, you hadn't interviewed a person at 34 Fairview or civilians associated with this incident, correct?
At that point, no civilians have been interviewed, no.
But at 10:41, Sergeant, you contacted Good Samaritan Hospital to inform them that, quote, Mr. O'Keefe was struck in the face with a cocktail glass, end quote, correct?
I do not recall contacting Good Samaritan Hospital.
May I approach?
Yes.
Oh, no. What? Ah, what happened?
I recall contacting Good Samaritan Hospital.
May I approach?
Yes.
Look at this document, pink.
Oh, that's annoying. My arrow key is right next to 0. If you hit 0, it starts the video over.
I never spoke.
One, stating the case due to a domestic situation. Did you say that?
I never spoke to Good Samaritan Hospital.
Did you say that there's a possibility that D was struck in the face with a cocktail glass?
Objection.
Sustained.
Did you ever contact anybody at any medical facility and indicate that the investigation was being treated as a suspicious, in quotation marks, because the victim appeared to have been struck in the face by a cocktail glass?
Objection.
Allow that. Did you ever say that?
Yes, Your Honor. Yes, I did say that to the medical examiner's operations desk.
Okay, so when I was asking you if you ever said it to Sam, you said, no, that's not true. That's never happened. You were correcting me on the fact that it happened at the medical examiner's office, not yes.
I responded and answered your question honestly, yes.
Okay, so honestly, you did, in fact, at 10:41 a.m., indicate to another professional involved in the investigation that the circumstance was being.
The double woman murders. Wade Wilson, he's part of the Unforgiven Supremacy Gang, according to the records. Why did he do it? What was his motive for it?
Treated as a physical assault at that point, correct?
I communicated our suspicions to the medical examiner's office.
And that was at 10:41 or thereabouts in the morning, correct?
That's correct.
Your initial investigation during those obviously critical hours, the beginning hours, led you to believe that there was at least a good possibility. You indicated that you made a phone call, that it was a physical altercation that led to John O'Keefe's death, correct?
That's correct, yes.
What steps did you take, sir, in those moments, to determine whether someone in the house at 34 Fairview may have been involved in that physical altercation that you suspected at the time?
As investigations developed, we followed the evidence and statements made. The steps I took was Trooper Proctor and I proceeded to an eyewitness who was also present at the scene when the victim was discovered and interviewed Ms. McCabe.
And prior to that, prior to interviewing Ms. McCabe, by the way, that was at Ms. McCabe's home, correct?
That's correct, yes.
Even though you believe that there may have been a physical altercation, you didn't ask anybody to come down to the station. Is that right? Any of the witnesses?
That's correct.
And you did not seek to actually go to the physical location of 34 Fairview in those next few hours?
That's correct.
Or the next few days, correct?
Not myself, no.
Okay. As a matter of fact, Trooper Proctor did not either, did he?
No, he did not.
You didn't secure the interior of the house as a potential crime scene. You certainly know how to do that, right?
That's a cop-out question. Do you want me to answer whether I did it or whether I know how to do it?
Well, I'll ask the question. If you can answer it, please answer it.
Okay.
Can you answer that question?
I can answer that question.
Why don't you answer both of them then?
First portion is we did not secure the home as a crime scene. And the second portion, yes, I do know how to do that.
And you didn't, as a Massachusetts State Police official, you didn't secure the outside as a crime scene either, did you?
I did not know.
To your knowledge, nobody else from Massachusetts State Police ever did either, did they?
Yes, they did.
How was that done and when?
When members of our office.
Wait, what? My first boyfriend had tattoos, one a vampire bite on his neck. He told people it was to represent society sucking the life out of him. Someone had to give it to him that idea because he wasn't that deep.
And the CERT team responded to that location and secured the front yard grass area and processed it.
That was at 5:45, 6 o'clock that night on the 29th?
I believe it was earlier, but I was not present, so I can't testify to the time.
So you don't know personally what they did to quote unquote secure or not secure the crime scene. You know they searched it, but in terms of securing it as a crime scene, you don't have personal knowledge to that.
I was not present.
Okay. You never took any photos of the interior of the house, correct?
I did not know.
You never caused CSSS to go inside the house and process that house as a crime scene, correct?
I did not, no.
No forensic criminalist at your direction ever went into 34 Fairview?
No, they did not.
And the people that you interviewed on January 29th, you already mentioned Ms. McCabe. The other people were her husband, Matt McCabe, correct?
That's correct.
And her brother-in-law, Brian Albert. Is that right?
That is correct.
And all three of them were interviewed where?
They were interviewed at the McCabe residence.
Now, yesterday when you testified, did you indicate that Brian Albert was not present in the home when you interviewed Matt McCabe and Jennifer McCabe?
They were not. He was not present in the dining room when we were interviewing each individual separately.
So if all three of them testified that he arrived before you arrived, they would all be wrong.
I did not see him in the home when we arrived, no.
I want to switch gears real quick to a couple of the physical items that you testified about yesterday, specifically the gray shirt, or the gray hoodie, and the orange shirt. You and Trooper Proctor collected both of those items you indicated from the floor of the hospital at Good Samaritan, correct?
That's correct.
You testified that you and Trooper Proctor immediately bagged both of those items. They were sort of sopping wet, I think you said.
That's correct.
You indicated that the bags were so wet that you had to take the items back out of the bags and then lay them out on, I think you said, butcher paper. Is that right?
The items were soaked and wet.
David, we covered that. She asked her lawyer to be nice to her. And I'm like, but Sarah, are you being nice to your lawyer?
They were bagged, double bagged, to prevent leakage of physiological fluids and the moisture coming off of it. And then once they were transported to the office, they were laid out on butcher paper in order to dry naturally.
So you went from Good Samaritan directly to Dighton, correct?
That is correct.
And then you went from Dighton directly to the Canton Police Department, after which you had seized the vehicle, correct? And a phone.
We seized the phone in the vehicle in Dighton and then followed the tow truck straight to the Canton Police Department.
So at some point, if you had received or gathered the wet clothing at Good Sam, went from Good Sam to Dighton Canton PD, at what point that evening did you finally get those items of clothing out and laid out to dry?
It was late that night, around 10 or so.
So where were the items in the meantime?
They were stored in the back passenger compartment of my pickup truck.
In those double bags?
Correct.
Who took control of the items to then lay them out late that night at the office?
I do not recall.
Oh, because I was really confused with the timeline, actually, because when Lolly went over this, I was like, wait, did they go to the hospital? Did they brought the clothes and the evidence and dropped it off at the evidence locker or whatever it's called, and then went back to the hospital and then went to Dighton to go pick up Karen Reed's SUV? I was very confused about the timeline.
You or Trooper Proctor?
I don't recall. I don't remember.
At some point, obviously, it was getting late. You'd been on duty for a long time that day. You went home at some point, correct?
At some point, yes.
Did you wait for those clothes to dry before you went home, or did you leave that in Trooper Proctor's hands?
No, once they were laid out in the processing area in the office, we went home.
Okay. Who would have controlled those items of evidence when you left?
Well, they're under lock and key within the secure area of the district attorney's office, so they're secured. Nobody's in physical control watching guard over them.
Who had access to that area?
Troopers in our office.
Meaning you, obviously?
Yes.
Trooper Proctor as well, correct?
Yes.
Ultimately, given the fact that he was the case officer, sort of in charge, he would have bagged those items up, been responsible for taking those items, tagging them, getting them stored wherever they need to be stored and processed, correct?
As a case officer, he could direct other people to perform those tasks for him. The evidence officers in the office log in the evidence, and once it was dried, it was sealed up, bagged, and put into storage. As far as who actually performed those tasks, I do not know.
Well, yesterday, Your Honor, may I approach the course, right? There's a couple of minutes.
Oh, sure, go ahead.
Thank you. Test. I'll bring these up to you in just a second, but just for familiarity's sake, do you recognize these two bags as bags that you brought to court with you yesterday?
They look familiar, yes.
Okay. This one has a 437 on it on my right. The one on my left has 438 on it. May I approach this one?
Yes.
I'm not going to ask you to open those. Don't worry about flooding up at this point. The bag on your left, which one is that, 437 or 438?
The bag on my left is 437.
437, okay. And you indicated that those items were bagged after the clothing was dried and then ultimately processed in, logged in, correct?
Once the items dried, they were bagged and logged in, waiting processing, yes.
But you didn't personally do that?
No, I did not, no.
Matter of fact, looking at the bag on your right, was been marked as Exhibit 430, help me, 438, thank you. That one has some writing on it, correct?
Yes, it has a lot of handwriting on it, yes.
And that, whose handwriting is that?
I don't know.
You've seen Trooper Proctor's handwriting 1,000 times, I guess, correct?
Not 1,000 times, but
Does it look like his writing?
it says Trooper Proctor on it, but other than that, I do not know what Trooper Proctor's handwriting looks like.
All right. It indicates that Trooper Proctor is the one that bagged that item or those items up, correct?
Yes, this bag indicates that the item was collected by Trooper Proctor on 129
Right.
at 10.
And it says Brockton, correct?
Good Samaritan Hospital in Brockton, yes.
You just took the question out of my mouth. That's where Good Samaritan Hospital is, correct?
That's correct.
And there's a tag or
Oh, hey, Rhiannon. How are you doing today? How's it going?
a printed label, looks like a label maker of some sort, that is on that physical bag, correct?
Yes.
Before we get to that, what's the description on that bag in handwriting?
I'm sorry, can you be specific as to description of what or?
Where it says description of items.
Description of enclosed evidence?
Correct.
It says 1 orange T-shirt, 1 gray long sleeve shirt.
Okay. So may I approach on it? Yes. Before I do that, just so I close this loop, what's the
I still think it's weird they put the two shirts together in the same bag and not separate.
description on the bag to your left, the one that looks like it's less wrinkled?
Number 437.
Yes. If you would read the same clothing description.
The description of enclosed evidence states sweatshirt with recovered items inside container.
Okay. May I approach now?
Yes.
Thank you. Yesterday when you opened, keep my voice up. Yesterday when you opened these two bags, this one, 437, has the gray sweatshirt in it. 438 has the orange T-shirt in it now, correct?
That's what was in the bag, yes.
All right. However, the bag indicates at one point, this bag, 438, the physical bag on
It's actually, I don't know, it's like a very subtle thing, but you know how Mr. Lawley keeps getting yelled by the judge to keep his voice up? Mr. Jackson just now announced, okay, I'm going to try to keep my voice up. I feel like that's a good way to try to appease the judge. Like, hey, judge, I'm aware of your issue with hearing and the AC stuff. I'm better than Mr. Lawley. And now I'm going to remind you that I'm going to try to keep my voice up. I don't know, I just feel like it's like a very subtle thing that he does. These like little subtle things. And it's good.
holding in my left hand had both the sweatshirt
Maybe
and
little jabs at Mr. Lawley as well.
T-shirt together, correct?
That's what the description is. I do not know if that was in case or in fact the case.
The reason you don't know is because you're not the one that bagged Trooper Proctor did, correct?
The reason I don't know is I wasn't present during the separation of those items, and I did not observe it taking place, nor was I made aware of how the items were separated or when.
You are aware, however, that tag that's on the label maker looking tag, the white tag that's on that bag indicates that indicates a date of February 4th, correct?
Wait, they bagged the shirts together at some point, right? And then I guess they separated it?
To bring that back up, I'm sorry, I ignored that.
My fault. Mayor, Your Honor?
Yes.
Let's direct your attention to the tag and the date associated with that tag.
The label maker tag does have the date February 4th, 2022 on bag number exhibit 438.
May I approach?
Yes.
Thank you, sir.
Yep.
That's obviously 6 days after the item was actually recovered on the 29th, correct?
Yes, it is.
So that indicates, at least based on that tag, that item was not booked into evidence and processed until 6 days after it was actually recovered on the floor at Good Samaritan Hospital. Is that right?
The date indicates February 4th, 2022.
Right, and that date would be indicative, in your experience, of the date that is moved into processing by some other folks, the evidence sergeants or whomever, or the evidence officers rather, or whomever, correct?
I can't speak to their procedures as far as when they print the date. That date could be when they printed the label, but the bag might have been tagged otherwise. I do not know that.
But there's no other tag on that bag that suggests an earlier date, correct?
There's just that one tag from the label maker.
My question to you, if you know, sir, and you may not know, is what was happening to these items between January 29th, after you lost sight of them that night on the butcher paper, and February 4th, when that tag indicates that they were first processed?
To the best of my knowledge, those items were drying on the butcher paper.
For 6 days?
If that's what the label maker says, yes, for 6 days. They were soaking wet.
And those would have been certainly accessible
He's like, I don't know. You have to ask Proctor for that.
to and in the possession of the lead case officer in the case, was Trooper Proctor, right?
Yes, if Trooper Proctor needed to review those items, he would have access to those items. Absolutely.
Yeah, I would suggest Sarah to learn how to knit maybe, but I wouldn't want her to use those crochet needles to stab anyone.
And you're also
Might be
aware
dangerous.
that the first actual log of any chain of custody for those items is March 14th, when they were finally submitted 6 weeks later to the crime lab.
That is not true. The first actual log of those items is when we collected them from the hospital.
Where's the log? I'm talking about physical log, like sign in, sign out log. Where's the log?
It's documented in the reports saying that we collected them.
I know that there's a report. Anybody can write a report, right? I can write a report. Doesn't mean anything. I'm asking for a log.
Objection.
So the objection sustained.
Obviously, when items move in and out of people's custody in an official capacity for the Massachusetts State Police, there's a law with that, correct?
It's documented, yes.
Or at least it should be, correct?
It's documented.
Where's the log of these items before March 14th?
It's documented in the report.
There is no log, is there, Sergeant?
I do not know.
Okay. I want to talk a little bit about some searches that Mr. Lally asked you about, February 4th and February 10th, very specifically. Both of those searches you were involved with out at 34 Fairview, correct?
Correct.
But, Sergeant, you didn't personally write a report about your conduct at 34 Fairview on either of those 2 dates. In other words, you didn't go back to the station and generate a report yourself.
I don't recall doing that, no.
There were no photos that you took of the items at the...
Really? The case will end last week of June? What was their ETA initially? Was it like 6 to 7 weeks?
At the location?
I did,
Most of photos, correct?
I did not take photos of the items.
Okay. And the first report that indicates anything that happened or was recovered at the location on either February 4th or February 10th, that was first notated in a report dated November 4th, 2023, year and several months later, correct?
If you say so, I do not know the exact date. That report would have to be presented to me.
May I approach?
Yes.
You don't have to read the whole thing, but if you can skip to the part that talks about the February 4th and February 10th searches. I'm sorry, I didn't realize you finished already. What's the date of that? Well, let me ask a foundational question. Does that refresh your recollection as to the date of the report that actually talks about the February 4th and February 10th searches?
It does.
And what's the date of that report, sir?
This report is dated November 4th, 2023.
Thank you. May I approach?
Yes.
Thank you. Now, as it relates to those 2 searches, I'd like to ask you a little bit about the February 4th search first. You indicated that you actually responded to 34 Fairview personally, correct?
I was responding to that location on my own. I personally responded, yes.
Okay. That was because you had received information that Chief Berkowitz had seen something or found something. Is that right? Chief Berkowitz from Canton PD.
That is not correct, no.
Okay. So when you got there, was Chief
Did Proctor write a report, or was there no report at all?
Berkowitz there?
Yes, he was.
You just happened to go by 34 Fairview at the exact same time on the exact same date as Chief Berkowitz, or was that coordinated in some way?
There was no coordination between me and Chief Berkowitz. As I testified, I had directed the troopers to go by the location. I planned to go by the location in the morning on the way to the office and in the afternoon on the way home, just to see if any more items would reveal themselves. So that morning, I was actually traveling to that location in order to conduct a view of the area to see if any more evidence had been revealed. Prior to my arrival, approximately while I was on Chapman Street, I received a call indicating that Chief Berkowitz was at the location, yes.
And was there also an Officer Lank, Sergeant Lank?
I do not know if Sergeant Lank was there, no.
Okay. Chief Berkowitz certainly was there.
Yes.
And Chief Berkowitz indicated that as he was driving by, he saw a piece of glass.
Yes.
And stopped his car and then started making phone calls.
I believe that's what he indicated to the caller, yes.
Did you question Chief Berkowitz about why he was driving by the location in the first place?
Absolutely not.
Okay. You knew at that point that the Canton Police Department had been recused because of at least an appearance or potential for a conflict of interest, correct?
I knew they recused themselves due to only in respect to interviews. They didn't want to conduct interviews with us side by side.
I mean, if there's conflict of interest, Sergeant, for a department, conducting the interviews is just one aspect of an investigation, correct?
I'm not going to speak to a conflict of interest, but yes, conducting an interview is just one aspect of the investigation, yes.
So is it your testimony that your understanding was they couldn't conduct interviews, but they could collect evidence, store evidence, write search warrants, get returns on search warrants, execute search warrants, conduct searches? They could do all that and not conduct interviews?
My understanding was they were recusing themselves from conducting interviews. They still allowed us to use their facilities. We utilized their conference room to conduct interviews. There was evidence being stored at their Sallyport, being the vehicle. So that was my understanding.
Isn't it true that you knew that the entirety of the Canton Police Department had recused itself because of a familiarity between one of their members, Kevin Albert, and the Albert family, on whose lawn John O'Keefe was found? That was the conflict, correct?
I knew that was the connection between them, yes.
And you understood, sir, that that agency was to have nothing, from an investigative standpoint, nothing to do with this investigation, correct?
They were not conducting the investigation, no.
But Trooper Proctor and you supervising him, y'all were conducting the investigation, right?
Our office was conducting the investigation.
So did you find it unusual or suspicious in any way that the chief of police for the conflicted Canton PD was the person driving by 34 Fairview looking for evidence?
Objection.
Can you answer that question, Sergeant?
He would
Do
have
I
to
have
repeat it.
to?
There's so much I can't.
There was a little wording. I'll try it again. Did you find that suspicious?
Which part? You have to repeat the whole thing.
That Chief Berkowitz from the conflicted Canton PD was at 34 Fairview looking for evidence.
The way you posed the question, I did not find it suspicious at all. He's the chief of the police in the town where he works, and he's driving down the street. I mean, that's not suspicious.
With a conflict of interest on the very case that he's driving by.
Objection.
Sustained.
You certainly knew, as a supervisor over the case officer, that any involvement by Canton Police Department, given the fact that there's a potential conflict, any involvement by them could compromise your otherwise clean investigation.
Hey, Kurt, how's it going? Happy Friday. There's a motion argument early on Monday regarding defense expert witnesses ×4 coming in too late in the trial by the CW, starting earlier than normal. For this Monday, or sorry, it already happened, they want Dr. Russell, dog bite expert, in.
You knew that, right?
I don't want to hear from, oh gosh, I mean, I sure will listen to the dog bite expert, but I want to hear from the person that's going to talk about how John O'Keefe was hit by the car, how it created the injuries on his arms and all that stuff. Like, I just want to know, what does Mr. Lawley think happened? How, like, what's their theory, I guess? That's what I want to see. I feel like Mr. Lawley has spent a lot of time trying to disprove the defense's theory, which is, like, great, but can we just focus on Karen Reed right now?
Not necessarily, no.
Did Chief Berkowitz disclose to you that morning on February 4th that he had been communicating with Brian Higgins and Brian Albert, two witnesses, on your case that morning?
Objection.
Sustained.
If you knew information about communication between and among Canton PD and your witnesses, you would find that inappropriate, would you not?
Objection.
Sustained.
You returned to the scene on February 10th, is that right? To conduct another search, you said.
I was present on the 10th, yes.
Who dispatched you back to, or did anybody dispatch you back to that location on February 10th? How did you end up there is a better way to ask it.
February 10th, just like previous days, we made
Oh, really? This Monday, 8 a.m.? Ooh.
plans to go to the location in the morning and the afternoon, drive by. I was on my way to work and to home. So I traveled that route on purpose. And as evidence revealed itself due to the natural melting of the snow, we would stop and collect the visible evidence.
You believe at this point, sir, that whatever you might collect at the scene would obviously be important, correct?
Anything we collected that had evidentiary value or presented itself as somehow related to the crime or the incident would be collected.
And it would be important to the investigation, right? You treat it as important.
It is a point, yes.
So my question is, especially as it relates to the February 10th search, where there were multiple items found, did you seek to have CSSS come out and actually either mark with GPS coordinates or measure with cross coordinates exactly where each item of evidence was found?
We did not do that. We had collected so much evidence already, and so much has been documented at that point, that we did not contact crime scene services to come back out and photograph more shards of glass and plastic. We simply collected it for processing.
So the location of each one of those items was not of that great importance to you, at least at that time?
It was of great importance as to the fact that it was located in the vicinity where the victim was found and in the vicinity of other items located of the same characteristic, shape, size, and color.
So that's my question, Sergeant. What does vicinity mean?
In the area.
Okay, what does area mean?
It's a location, specific location.
Okay, are we talking about, if we do this all day, I guess, are we talking about an area of 5 feet or an area of 50 feet?
Based on where the items were recovered, we're talking about an area approximately of 30 square feet between the roadway into the grass.
We saw photographs, Sergeant, of items that were butted up against a fire hydrant in one instance, correct? Yes?
That's correct, yes.
A drinking straw that's out in the road, correct?
That's correct.
Another shard of glass that's in the grass, closer to the flagpole, correct?
Correct.
A hat that's under the snow, adjacent to the left side of the flagpole, correct? I'm sorry, it wasn't. It was closer to the electrical box, wasn't it?
No, the pictures documented where the hat was. It was to the right of the flagpole.
So these shards of glass, the point I'm asking is, did you seek to use basic cross coordinates, measurements from something that you know is a known object, like, for instance, I don't know, a flagpole or a fire hydrant? 27 inches to the north and a foot and a half to the south of those two known points. That would give you a cross coordinate, correct?
It would document the exact location, correct?
And you did not do that with any of these items, correct?
The items that were not photographed were not also GPS located, but they were within the same vicinity of where the other items were collected.
But again, now we're back to the same question. Your word for vicinity might be different than my word for vicinity, right?
Objection.
Sustained.
To memorialize on the evidence bag or in some other way exactly where they're found, who found them, the date, time, etc. Correct?
We do the best we can to document all known information on each evidence item bagged at the time.
And in terms of the February 10th search, I want to just ask you a couple of quick questions about that evidence bag. Did you bag the items into a single evidence bag that you found that day, or do you recall?
I would have to see the bag. If you have those available, I'll take a look. I can answer.
With course permission, exhibit, I think it's 310, where you're at. I don't have the evidence bag with me, so if you
210, Buchanan, 15 or 15? 5 pieces? I'm not sure what it says.
don't, I can certainly ask the space to enlarge it.
If you can enlarge it, please.
9 a.m.
Just push it right. Madam Mayor, Coach.
Yes.
I didn't realize I've got a photograph of it.
Do you need the lights on, Sergeant?
Please. Thank you.
Should make it easier. The date of collection is February 10th. Is that right?
That's what it says, yes.
Okay. And it indicates multiple pieces of red, black, and clear plastic, right? It actually says 6 pieces of red, black, and clear plastic, correct?
That's correct.
But that is not an evidence bag that was filled out by you.
I did not fill that bag out, no.
As a matter of fact, that's Trooper Proctor's handwriting.
I do not know what Trooper Proctor's handwriting is. I cannot confirm that that's his handwriting.
But it's not your handwriting.
It is not my handwriting, no.
So, are you aware that this particular bag, that bag that contained those 6 items of plastic material that you already deemed was incredibly important to the investigation, was never going into any evidence until March 14th, the date that it was submitted to the crime lab?
I was not aware of that, no.
We can take that
March
down.
14.
If I may approach, Your Honor?
Yes.
You're welcome.
Did you ever draft a report yourself documenting the recovery of those 6 items and the other 14 items that you said that you found on the same date, February 10th?
I did not, no.
Did you leave that assuming that Trooper Proctor would document that?
Objection.
Sustained. Ask it differently.
I'll ask it another way if I can. Did you believe that you didn't need to write a report, Sergeant, because Trooper Proctor would take care of that?
I knew that it would be documented. It was already documented on the actual.
Yeah, that's what I was thinking. I was like, maybe he didn't write a report because Proctor was going to do it. And then when he realized Proctor didn't do it, maybe. That's why he wrote it in November of 2023, maybe?
Bag as far as who collected it, when, where, what it was, and a report eventually would be authored on it.
But the wear, for all these very intricate pieces, the wear is left to 3430 on that, correct?
Objection.
I'll allow it.
Is that right?
The general vicinity
Oh, Lolly made the motion. Okay, because the defense wants to bring a dog. Gotcha. Okay.
location of the other items collected and documented with photographs was consistent with the same locations this was collected.
I want to shift gears for just a second. Well, actually, I want to ask one final question about that item. Based on the documentation that you just mentioned, that it's documented on the bag, and if the bag is presented to the crime lab on on March 14th, some 5 weeks later, those items were completely unaccounted for from a log standpoint for the entire time from when they were collected until they were booked at the crime lab, correct?
Objection.
Sustained. Ask it differently.
Possession of those items for those 4, 5, 6 weeks.
Are you talking about the items that were just displayed on the screen?
I am, sir.
I did not.
Now I'd like to shift gears to a ring video that you saw yesterday. It's in Exhibit 6, video number 153. That may mean nothing to you. It's the 5:07 a.m. video of Ms. Reed's car pulling out of the One Meadows garage. Do you remember that video?
I do.
Okay. You indicated yesterday on questioning, under questioning by Mr. Lally that Ms. Reed's car came in contact with or close to coming in contact with the other vehicle, the Traverse, in the video. Is that right?
The video, as I watched the video, I observed the vehicle come near Mr. O'Keefe's car.
Okay, that's what I want to talk about. With the court's permission, maybe play that video one more time.
Did they not review the video? I think it's weird that they say near, because when you watch the video, you can see that Mr. O'Keefe's car, John O'Keefe's car, like juts a little bit. It's like, cheat.
Maybe you can pull that up and then ask you to pause it and get out of the way.
I think it's okay for them to be like, yeah, it seems like it tapped it.
Okay, can you just play that for a quick second? No, ask you to pause it. Pause. Does that appear to be, I'm just pausing it in the first 2 or 3 seconds, does that appear to be the video that you saw yesterday?
It appears that way, yes.
Okay. Mr. Bates, if you could enlarge the area around the left rear tire of the Traverse. I'm going to ask you, sir, if you'll pay close attention to what's been zoomed, and when the SUV gets close to it, I'm going to pause it and ask you another question. Can you go ahead and play this?
Your Honor, I'm going to object to this.
So why don't we pause the screen, take it down, and I'll see you at sidebar.
Oh, defense in their technology.
I'm going to go ahead and enlarge that, the rear area of the traverse. And I'm asking you to pay special attention to that
Wow.
wheel.
I'm surprised that they can enlarge it like
Which
this.
you may or may not see. Okay, pause it. Okay, in about the next 3 seconds, Sergeant, I'm asking you to pay special attention to the wheel. Go ahead. We can have the lights on.
Did Lolly not go through this with this trooper? Because I think the trooper's saying that, like, oh, it got close to. I think he should just be like, yeah, it hit it. It tapped it. And be like, so what?
Sergeant, were you able to see that video? I know it's not the clearest thing in the world. Were you able to see that video okay?
Yes.
What did you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling,
Jiggle, jiggle.
it appears that there is movement,
Jiggle,
but the
jiggle.
video speaks for itself.
What would you assess based on the movement of the rear wheel of the Traverse about whether or not the two vehicles came in contact with one another?
Objection.
Sustained.
Okay. May I have just a moment, Your Honor?
Yes.
You have that where you slip. You remember that one? Mr. Riley paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was icy that day. So if there's documentation of me slipping,
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos. It's Exhibit 446, but I don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to?
Hey, what's up, Aaron? Yeah, I mean, maybe Mr. Lolly will have someone that do a reenactment with a car like exactly like Karen's SUV, and then John O'Keefe's car to see if she were to back up like that, if it wouldn't line up, and if it's possible to crack the taillight, right? I don't know. Maybe he'll do that.
Canton to
Maybe he
Canton
won't.
PD to retrieve any or all of the videos of the Sallyport. You yourself.
I did go to Canton and collect already extracted video,
Okay.
but it was a portion of video surveillance. I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect a portion of the video?
I don't remember. I don't remember. I'm sorry.
Did you review well, let me ask it this way. Did you collect a video that was sought on about April 23rd, April 24th this year, just a few weeks ago?
Did I collect it?
Correct.
I did not collect that video of April this year, no.
You're aware that the video that you saw yesterday was in fact collected after the trial started in April of 2024?
Objection.
Sustained.
Are you aware of when that video that we saw yesterday was collected?
Objection.
I am not aware.
Okay. Was yesterday the first time you'd seen that video?
No.
When had you seen that video previously?
A couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
Sustained.
Mr. Lolly?
The DA?
Why am I lisping so much? Oh my God, what's going on?
Objection.
Sustained.
I filmed a video
Did you
yesterday and I
ever
was
have any
listening
kind
to.
of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yes.
You are unmuted.
Yes.
Thank you. Sergeant, did you have any meetings or communications with Mr. Lally in anticipation of your testimony?
Yes.
When was that?
It was about 2 weeks ago, and then last week, I believe.
And what was discussed? Generally,
Generally, we discussed the portions of the case that I would be presenting.
did you write a report about your communications with Mr. Lally?
No, I did not.
Were you shown any of the videos that you've seen here?
Lolly's like, listen, Mr. Buchanan, I can't call Proctor, okay? I know it's going to suck. We're going to have to call you up there, and you're probably going to get all the hate directed at Proctor towards you, but I'm going to need you to go up there and testify for me.
Anticipation of your testimony.
I can't get Proctor in, so you need to do your best to get as much information in as possible.
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Sallyport that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so I don't remember exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You have seen that one before?
Yes.
And that was with Mr. Lally, correct?
That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that exhibit 446 for a second, and then I'll show it to you. You indicated that the video.
Yeah, that's not a really good feeling, is it? Aaron says, I have very little faith in What's it called? Folly. What's his name? Lolly? Yeah, I think we try to give him benefit of the doubt. Like, oh, maybe he's just getting there. Maybe he's just stumbling a little bit. Maybe there's conflict of scheduling, which is why certain testimonies can't testify earlier. Experts, blah, 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 blah. I don't know. I have read his motions. His motions are pretty straightforward, easy to understand. Maybe it's when he speaks, it's a little bit of a struggle for him. And then also how he presents this case. I don't know. I'm like, we're day 21. I don't know. Shall we stop making excuses for Mr. Lolly? But I do want to point out that it has to be really hard because he's the one that's doing all the direct examination. Where's Mr. Morrissey at? Where's the district attorney? Why is Lolly doing everything?
Everything that you saw yesterday was true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place in an accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to find out. And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear tail light in any fashion? And you said never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, or touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion, right? That right rear tail light.
The right rear damaged tail light, correct.
With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
Before we begin playing it, Mr. Bates, if you wouldn't mind, may I inquire, Your Honor, of the witness, just to lay foundation? Sir, did you recognize this as being the video that you saw yesterday?
It does look accurate,
okay.
Yes.
I just want to make sure we're on the same page. This is 446, just so you have it in mind if I reference that. So basically, you could play that. And I think it's runtime 120. Pause it. Do you recognize that as the video we saw yesterday?
Yes, I do.
Very briefly, if you could move to time of day, 5:37:05.
The banner does block the timestamp, but honestly, the timestamp is written in blue. Can't really even see it anyways. I struggled seeing it.
Yes. With court's permission, can we play this one?
Yes.
All right, that shows.
Wait, what? The sole of the shoes are not the same color? They're so messed up? Let me go do my pictures.
The vehicle coming into the Sallyport, and we're looking at which side of the vehicle?
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle.
The one that was found at the scene, it looks like it's white. I don't think we have a picture of the one that was found on John O'Keefe. Do we have a picture of it?
I do not know why it is inverted, but that's the way it was presented, collected and presented from Canton Police.
Can you see a timestamp or time and date stamp on the bottom of that? It's in blue.
I cannot know.
Okay. Does it appear that time and date
Yeah, we could barely see the timestamp. Can they zoom in for us?
stamp, if you can't read every letter on it, that is incorrect order? In other words, that's not inverted.
I cannot read it now.
Wait, is there a picture of the other shoe? I don't think we saw it. The one that was on John O'Keefe? I remember seeing a pile of clothes at the hospital. I don't know if the shoe was there. Yeah, I just remember the shoe being in the snow.
All right, let's go and play this for a second. Who is that just got out of the car?
I do not know. I think that's the tow truck driver. He would have the only access to the vehicle.
Okay.
We did not touch the vehicle.
Who's that on the left?
I missed it. I was looking down at the laser pointer. I do not know. I know for a fact I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
That was playing, and I didn't realize it was playing while you were talking.
Did they show it in the trial, guys? Corky, the photo of his shoe in the snow had a black sole and is a left shoe. The one that Buchanan pulls out in court is bright white sole. It's a right shoe. Oh, you're right. He did pull it out. Give me a second then. Give me a second. Let me take a look at it. Let's see. I need to pull out Buchanan's testimony.
Winter hat.
All right, give me a second. I'll look for it.
So,
did he pull it out?
A winter hat.
Was that
that was playing.
Was that yesterday? Sorry, not yesterday, but was it the day before when he was on direct examination? Where they pulled out the clothes and stuff like that? Can you link it in my Discord? Here, I got it here. Hold on, give me a second.
Yesterday, when you testified, you indicated that the two individuals in this scene were you and Trooper Proctor, correct?
Not correct. There was two individuals in the rear of the vehicle I shined my light to. That was me and Trooper Proctor.
Do you see Trooper Proctor toward the back of the rear of the vehicle there?
I have it. Hold on.
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
What's the person in that in the video to the left, to the rear of the car, is wearing a black hat, correct?
I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically. I can't testify to that.
There's no magic about this. It's your testimony. I'm just asking you what you see.
I don't see that. No.
So, let's go ahead and play it this way. Do you see the person toward the back of the vehicle walking toward the opposite side of the SUV?
I do.
What area does he appear to be going to?
He appears to be going towards the rear passenger side of the vehicle, although...
Okay, I found it. I found the picture. And then... Is this the shoe? No, this is the hat. Oh god, I don't have my glasses on. Where are the shoes? Are we comparing these two pictures? Can you guys see? That's a shoe, right? That was in the snow? And then... I'm like trying to see if I can tell if it's left side or right side. I don't know if I can tell. It looks like left side. Are these the two that I'm comparing? It's the same white sole sneaker. It's dark and it happens when you take a picture in the dark. Are we comparing these two? My chat's a little bit delayed, so I'll wait. They look the same to me. Are you talking about like this right here? That looks like black? That just looks like it's like part of the concrete or something. They look the same to me.
It does not appear so because the video is inverted, a mirror image.
And I don't know if that's going to be something that the jury is going to catch, unless Jackson's going to bring out the shoe again and compare it.
Where he's going.
And Sergeant Buchanan, you testified for at least a half an hour about this video yesterday, correct?
I'm sorry, it was a long day. I don't know the timing of how long I testified.
You significantly testified about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Correct.
You testified that it was reflective of your observations of what's happening in that Sallyport that evening, correct?
I testified that this
I can't tell. The shoe he wore is not pictured.
is a accurate scene and collection of video evidence from the Sallyport.
And as that truck sits in that Sallyport, just like this, it appears from all perspectives.
Yeah, because here's my understanding. Either it's supposed to be one sole is white, one sole is black, or maybe they're the same exact shoe being used for two different shoes. I couldn't tell.
Looking at is the passenger side of the car, and that right rear taillight is
All right, let me go back to Mr. Jackson because I feel like he's got something here.
This video.
And you testified that it was true and accurate, correct?
Correct.
You testified that it was reflective of your observations of what's happening in that Sallyport that evening, correct?
I testified that this is a accurate scene and collection of video evidence from the Sallyport.
And as that truck sits in that Sallyport, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
I'm sorry, can you repeat the question?
From this perspective, from the perspective that the jurors are looking at,
okay.
From all indications, that would appear to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your question by Mr. Lally, not once did you mention that this video is actually completely inverted.
Because I don't think he realized, but I mean, I don't know why Mr. Lally didn't realize. Mr. Lally had to have watched that footage so many times, no?
I did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected, correct?
Objection.
Sustained.
The person with the winter cap appears to walk directly to the what ultimately should be the right rear taillight of this car, correct?
That's the vicinity, yes. That's where he is. Yeah.
Because if anything, I thought it'd be better for the defense to not point out that it's inverted, because then the jury could just be like, oh, I see like a little red taillight right there, right?
Positive. I'd like you to pay attention to the right rear of this car. And I know we're completely backward, but it's the far corner of the car. Do you see a person's head there?
It appears as if someone's still there.
And that person is located at or near what portion of the car?
In real life or in...
If he worked for Canton PD and he didn't point it out, I'd be like, okay, you should have known. I think the witness on the stand just generally doesn't remember, but I think Mr. Lally, like, come on, you should have caught that.
As it's depicted.
Is the person in real life, near the right rear taillight of the car?
Yes.
Matter of fact, standing there, hovering around there, correct?
We don't know the distance that they are in proximity to the
hold on a second.
actual vehicle. We just know that they're behind the vehicle. That
looks like it's pretty close, doesn't it? Sergeant?
Objection.
Does that look like he's in close proximity to the right rear taillight?
As I said, I can't tell how far away he is from the vehicle.
It's right there, sir. You can't tell that he's right next to the right rear taillight?
Objection.
Sustained.
All right. I want you to pay attention to what that person does as soon as the other person comes out from behind that car. So you see him move. Got it. You see that person move?
I saw movement in the frame, yes.
Right when the other person car. So you see him move. Got it. You see that person move?
I saw movement in the frame, yes.
Right when the other person is in eyesight of the person toward the right rear, correct?
I mean, the video speaks for itself.
Wait, where are my glasses? Oh, do I have my glasses here? It's just, I don't know, it's just pixelated. This surveillance footage sucks. Can they upgrade their fucking videos, please? Okay, let's watch.
So you see him move. Got it. You see that person move?
Oh, like the timestamp jump? I mean, this is motion activated, right?
I saw movement in the frame, yes.
Right when the other person is in eyesight of the person toward the right rear, correct?
I mean, the video speaks for itself.
Yeah, it does.
No. Objection, Your Honor.
The objection sustained. No commenting, Mr. Jackson. We've talked about that.
I'm going to ask Mr. Bates to back it up because there's one other issue I want you to pay attention to.
They should do the zoom in thing that they used earlier.
If you can, right at this moment or right before this moment, and that is the timestamp. You can back it up maybe 10 seconds.
Oh, I can't see the timestamp.
Right about there.
Oh, wait, what does the timestamp say?
Don't play yet. Instead of paying attention to the individuals, I'm going to ask you, can you see?
I'm going to slow it down for you guys.
May I approach the screen, Your Honor?
Yes.
can you see the timestamp at 5:37 and 37 seconds p.m.? Can you see that from where you're at?
No, I cannot.
Me neither. That's why I had to walk up to it. Let's play it for about 10 seconds. Pause it. Pause it. Did you see another person just appear toward the rear end of the car?
There was a fog of some sorts. It did appear as if a person was actually in. There was two people back there, and two people walked away, or one person walked away.
The timestamp jumped to 5:38:01. Correct?
I cannot see the timestamp, sir.
Okay. Did it appear that there was an anomaly?
A ghost? So it was 5:37, and then 5:38:01. I mean, I would have just assumed it was just like the motion capture thing detected motion, and then it thought it didn't detect motion, and that's why there's a time jump, and then that person appeared. I guess.
Person walked away.
The timestamp jumped to 5:38:01. Correct?
I cannot see the timestamp, sir.
Okay. Did it appear that there was an anomaly? There was a portion of that video that was deleted. Or it's missing. Not deleted, but just missing.
Objection.
Can you tell that? Does it appear that way?
Yeah, I guess like when Lolly presents the video, I think what they did was they stitched it all together. It might have been better to just present them separately for each motion activated activity. That way it's like, okay, well, here's motion activated activity number 1, number 2, number 3, number 4. When it's all stitched together and the defense is up there, defense is going to be like, whoa, it looks like, someone deleted it. That looks pretty weird. I wonder if that would have worked better for Lolly to just to have the video separately uploaded. And I thought that's what they did because they had so many files when he was like telling the person to go through like the photos or surveillance and all that stuff. They had like separate files on there. Did they stitch this one together?
What do you, Sergeant?
No, Your Honor, I cannot tell what is happening with the video.
Say ghost. Say it. Say ghost.
If you take a close look at there's a classic police car in that Sallyport, correct?
There's an antique vehicle there, yes.
If you take a close look at the trunk of that vehicle, see the word police?
Right, because I'm wondering since the main DA Morrissey, I haven't really seen them participate in this trial. I don't know. Are they there? Are they just like are they doing something else? I wonder if Lolly was just like super overworked. Maybe Morrissey wasn't helping. But then when the motions were written, I noticed that it was Morrissey and Lolly on the bottom of like the end of the pages. So I'm like, maybe Lolly just did everything and he was just like really overworked and he was just really fucking tired and he missed himself. Maybe. I don't know.
Yes, I believe I can read that, yes.
And it's backward, correct?
It is mirrored, correct.
That's a good indication that this is an inverted video, right?
It appears that way, yes.
And if we were to fast forward at...
So I don't think Lolly purposely brought in a video that's inverted because like I said, the view that the jury would have gotten would have been the taillight that's supposed to be busted. But as the car's brought in, you can see that there's like red on there. It's hard to see because, it's kind of blurry and it kind of sucks, but you can see that it's red as you're bringing it in. So if anything, Lolly wouldn't want it to show that side. He wouldn't want it to be inverted because the jury's going to be like, oh, wait, here's a taillight that looks like it hit John O'Keefe, but we could see red on there. So that's why I think Lolly missed it.
5:42.
Also, in this Sallyport, I guess there's a garage door here, and then there's also a garage door here, right? It seems like I see like a little bit of like shit over there. That's why there's like snow on both sides. Is there a garage door there?
Another 20 seconds. There you go. You just play at this point. Oh, you give them a call. How's it? You see the Sallyport garage came down?
Yes,
You see a number on the garage?
I do.
Is that correct?
What is correct?
Does the number appear correct? How do you make it 4?
No, the number's in the mirror image, yes.
I just wanted to make the point. Everything in this video is completely correct.
It's not backwards, it's mirrored, reversed. You can look yourself in the mirror in the morning, you still see your own face. It's not backwards.
But my mirror image is not an accurate depiction of who I am. My actual physical appearance is who I am, correct?
Objection.
Sustained.
A mirror image, Sergeant, is not an accurate video of this, is it?
Objection.
It's a mirror image by definition.
Sustained. Ask it differently, Mr. Jackson.
I don't like to run, thank you. I have a thumb drive that I'd like to have marked with court permission.
Oh, I have to go to physical therapy soon. Shit, what time's my physical therapy appointment? Ah!
Does Mr. Lally know what's on this thumb drive without you telling us?
I do not.
Okay.
Oh, wait, we're almost done anyways. Okay, I'm good.
We can approach it, I can certainly bring it up.
We're trying to wrap up our morning.
Yes,
It's marked for identification.
if I may, Your Honor. I'd like to play the first 10 seconds of that video.
No. We'll come to something. It's marked for identification, right, Mr. Jackson?
You are unmuted.
Okay, so we'll just wait. Jurors, I know that you want to know when this case is going to end, and I don't mean that in any negative way.
Yeah, the jury's like, hello? How many more weeks of work am I going to have to miss for this shit?
After speaking with the lawyers, I can safely say that you will get this case for your deliberations sometime the last week in June.
Jesus, last week of June. I didn't think this trial was going to go till the end of June because I think I scheduled some stuff in end of June.
We'll know better next week. We will not be in session next Tuesday. We will go full day.
No session next Tuesday. Oh, let me get my notes out, y'all. Would it help if I put in the communities channel, my YouTube channel, the court scheduling? Okay, so she said no session next Tuesday.
We'll know better next week. We will not be
Let's see. Sometime the last week of June, we'll know better next week.
in session next Tuesday.
Okay.
We will go full days, Monday, Wednesday, Thursday, Friday next week. We will not be in session next Tuesday.
I actually prefer, instead of doing no court on a full day, I prefer like the half days.
I have to give you those cautions again. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case.
You are muted.
You are muted. When did this case start again? Was it beginning of... Was it April? Or May? Sorry, we're day 21. But these are open and considered business days. Those were like 5 weeks in.
Thank you.
You may be seated.
All right, so I received a motion from the Commonwealth this morning that I have not had an opportunity to read yet. It's on my desk. I'd like to go spend a few minutes looking at that and come back out at 12 o'clock on that.
Did they argue this over? Wait, hold on.
In order for us to argue it,
Yes. Do you need?
I didn't get it either.
Okay.
You've been busy.
All right.
Could we do it on Monday?
I want to get as much evidence in as we can each day. We can do it at 8:30 Monday morning, I think. Madam Court Reporter, can we do it at 8:30? Yeah. Jim?
Sure. Absolutely fine with us. Not that it matters. But we love that.
Can we do it at 8:30 Monday morning?
If that's what the court wants, yes.
Lolly's like, oh, I gotta wake up early.
Yeah, we'll
You
have a
more
hearing
early?
on it at 8:30 Monday. Are you around tomorrow? Are you around tomorrow?
Oh, am I? Yes, absolutely.
Do you want to do it tomorrow morning?
If I had a preference, I would say Monday.
All right, we'll do Monday morning at 8:30.
I'm sorry. Monday. Okay, great.
And if you want to put something in writing, just email it to us this weekend.
Will do.
Okay.
Thank you.
All right, we'll see you then.
All rise for the court, please.
I hope you have a good weekend, Mr. Lally. I hope you get some rest. Hi, Ola. How are you doing today? Dude, he must be stressed the fuck out. Holy.
Hey there, Karen Reed trial watchers. This is a law and...
Hi, Jesse. All right, so if y'all missed it earlier, we talked about Sarah Boone. We watched her hearing today. Her trial is set for October 7. They're going to do I don't know, it's like maybe like a pre-trial meeting and discuss, but Sarah Boone is not happy with her 8th attorney. Surprise, surprise, right? Judge did mention that there is a 58-page letter that Sarah Boone, I guess, is going to submit. I will let you guys know when that's posted. Maybe they did it already. Let me check, actually. Let me check. Criminal case records. So we covered Sarah Boone early. If you guys missed it, watch the beginning of the stream. And then I'll probably chop the video as well. That way it's like separate from the stream. Sarah Boone talked about her fans out there. Something about making GoFundMe. Wink, wink, wink. No, the letter has not been updated yet. Okay, so there's a trial management conference September 24th, and then October 7th, trial. I don't think the trial's going to happen. It's been so many delays. And it seems like her attorney, Patricia Cashman, it seems like, you know, she's kind of nudging the judge that, hey, maybe Sarah Boone should just represent herself, and maybe I should just not be a part of this. I don't know, maybe. But she didn't file a motion to withdraw, at least yet, but we'll see if that's going to happen. And then we got into day 21, starting with a direct examination of Yuri Buchanek. I'm trying to pronounce it the way he pronounced on the stand, but I don't remember how he said it. Buchanek, maybe? We start with his direct examination, did a little bit of that. Still no mention of the Sallyport being inverted by Mr. Lally. It seems like, let's see, where are my... Oh, let me go back to my notes. Okay, I don't really have a lot of notes from today because a lot of today was just like kind of listening. But they talked about the Ring camera that was at John O'Keefe's house. It's motion activated. Remember, we had a footage of Karen Reed leaving 34. Sorry. Start over. We had a video of Karen Reed leaving John O'Keefe's house in the morning when she went out to go look for him. And it has her backing up into his car. We also have footage of her arriving at John's house with Carrie, with Jen McCabe, and that's it. So they made it a point to say that, like, oh, there's no Ring video of Karen Reed arriving after dropping John O'Keefe off at 34 Fairview. And then there's also no footage of when apparently Carrie and Jen McCabe testified that Karen Reed, when they arrived at John O'Keefe's house, I don't know if it was when they arrived or when they left. I think there's some confusion about when that actually happened. Jen McCabe said it was when they arrived. I didn't see that on the Ring footage because when they arrived, they ran to the house. Kiera Roberts was like, oh, it's when they arrived, but actually it might be when we left. So that's kind of like, we're not sure about that. But there's no Ring footage of them all leaving John O'Keefe's house afterwards. So what the state is nudging at is like, oh, did Karen Reed delete this? Did she delete the time that she arrived at John's house? And did she delete when she was showing the women the busted taillight? Or maybe it didn't happen. And I did mention that I do have a Ring camera as well. And then there are times where it doesn't capture motion. I just want to point that out. And then they talked about, let's see, going back to the crime scene over the next couple of days. They located the baseball cap. There was a drinking straw, more pieces of plastic, and Buchanek made it a point that, like, hey guys, like, our team, let's make it a point every day, stop by this house, and see if we can collect more evidence as more and more snow melts. And that's what they did. They go by the house, they drive by to see if there's more pieces. They collected some. At some point, February 3rd, so this is a couple days after John O'Keefe's was found and declared dead, him and Proctor did meet with Higgins. Higgins provided them with a Sallyport extraction, a digital copy of Sallyport extraction, showing that, like, oh, this is my communications with Karen Reed. This is my communications with John O'Keefe. Probably to show that, like, oh, me and Karen Reed, we've been flirting a little bit, so here are the messages. And then we got to honestly, I don't know why I had high hopes for this, but they were like, oh, there's an audio recording. And I was like, yes, audio recording, because we don't have body cam footages. We don't have interrogation videos. We don't have anything, at least not that's been presented so far. But then they mentioned there's a June 9 recording of when they talked to Karen Reed, but it was like a blip of nothing. I don't know. I think Lolly was trying to maybe clean it up and then do follow-up questions to say why he showed that audio, or he, presented the audio footage to the jury, but there was some objections sustained, so he wasn't really able to get into it. But in the audio recording, I was able to hear Karen say, "You're aware he was beaten up with Brian, Colin Albert. I mean, we're all in the same joke, right? My taillights crack and John's just pulverized." But that was in June 9. Not like the day that John was found or a couple days afterwards. That was in June 9. And then he told her to like, oh, you need to talk to us with attorney present or something like that. But yeah, so there's a bunch of objections sustained, maybe like 1 or 2, I think. So Lolly wasn't able to really talk to us about that. We did hear that 2024 this year, we got some DNA, some cheek swabs from Buchanan and Proctor, probably to see if they tampered with evidence maybe, and to prove that they didn't. I don't know. We just heard that they got their cheek swabs. I don't remember any follow-up questions about that. And then we got into the cross-examination by Mr. Alan Jackson. Jackson was saying that like, oh, Proctor was the one that received the ring footage, right? And he's like, yeah, it was him. He was the one that logged into evidence. They were talking about whether or not there was any activity logged by Ring. It seems like Jackson was trying to say that like, oh, you guys did get activity logged, and it showed that Karen Reed never logged in to do things. But Buchanan says, oh, we didn't get any activity logs. There was a little bit back and forth between that. It seems like the Ring people contacted Proctor and provided like a Dropbox link. I want to know what was in the Dropbox links. I want to know if we're going to hear from the Ring people at all. Are we going to hear testimonies from the Ring people who are like, oh, hey, they contacted me, here's the data. And then are we going to have like an expert who looked through the Ring stuff and then it's going to testify about that and to show that like, oh, whether or not there was footages deleted, whether it was not deleted? I don't know. Because to me, like, yes, it does sound, when I first heard about Ring footage being deleted at John O'Keefe's house, I thought it was weird too. However, if there's no expert to testify that something was deleted, I don't know. I don't know if it's really going to mean anything to me, right? It just might be one of those things where it's like, okay, it's weird, but that's about it. I'll have to wait to hear from an expert. Ain't got nothing from that yet. Then they talked about, oh God, this is pretty interesting. So when Buchanan testified and Lolly was asking the questions, it seems like they got their evidence in a timely manner. They went to the hospital. They collected the clothing. They took the clothing back to process into the evidence locker, but they had to dry it out first. And then they put it into the evidence, right? But when they did the cross-examination, Jackson was like, oh, well, it seems like you guys didn't drop the clothes off until 10 p.m. that day because you guys collected the clothes. You guys went to Dayton to go pick up Karen Reed's car. And it wasn't until 10 p.m. that day that you guys actually dropped off the clothes and to let it dry. And then it was like, oh, how long do you guys leave the clothes to dry out for? And then the guy was like, oh, I don't know, maybe 6 days because it seems like the clothes wasn't processed until 6 days afterwards. So it's like, did they leave the clothes out for 6 days? Or he doesn't really know because he doesn't know who was the one that took the clothes and put in the bags or whatever. Maybe it was Proctor, I think. I think he was saying it could have been Proctor, or it could have been someone else, but he wasn't the one that did it. Okay. Then they talked about, this report. Okay, so the searches for February 4, February 10, and some other stuff, I think. It seems like there was no report was made by Buchanan, but there was a report that he made in November 4th of 2023. So I don't know if Buchanan was like, oh, I thought Proctor was going to report, but he didn't, so I guess I'll do it now, November 2023. Or was it like, oh, Proctor did make a report, but then now that we don't believe Proctor, I guess I'll make a report. But I mean, that was kind of interesting. And then the February 10 collection, the stuff that they collected, the pieces of plastic and all that stuff, was not presented to the crime lab until March 14. I don't know what's happening here. I don't know. Could take days to draw on paper. To lay it flat, I would say maybe max, like, let's say if it doesn't dry the first night, maybe the next day it's still a little bit damp. But I mean, 6 days. But I don't think it took, he doesn't know though. I think he was just making an assumption that, oh, maybe it was laid out to dry for 6 days. But he doesn't know if it was 6 days or if someone else took possession of it and they didn't they didn't label it until 6 days afterwards or 2 days afterwards or 3 days afterwards. So I think he was just trying to give an answer, but he should just said, I don't know. Because he was the one that did it. But yeah, there's just some interesting stuff, you know. Kiki, thanks for hanging out with us. I did hear about the children testified though, but I don't know. This is something I read in a court doc though, but Mr. Lally wrote it. So it said that the children believe that Karen Reed does have access to the Ring camera stuff, and that could be accessed through the family computer. So the extraction, I'm just going off what he said in his testimony. He said that they met with Higgins and they had a Sallyport extraction, digital copy of the Sallyport extraction. So I'm like, okay, so maybe Mr. Lally will show that later. But I did see that there were screenshots. So I'm just waiting to see if, you know, maybe later down the road, maybe there are the Sallyport extractions and maybe Mr. Lally will have the expert to talk about that. Because Mr. Lally did mention, I think in his opening statement, that he has 3 experts from Sallyport, and then one of them was the one who wrote the software for Sallyport. So I don't know. Maybe it was just the screenshots. Maybe with Higgins, he could only show the screenshots, but they have to wait till the expert goes out there and testify to talk about the actual Sallyport extraction report itself. I mean, because like honestly, if you went to what was it, like the booth at the FBI thing where you plug in your phone and then you do like the extractions and stuff like that, I'm like, it has to be more than just screenshots, right? So I'm waiting for that, but don't worry, I still remember in my mind that they went over the screenshots. All right, but other than that, I mean, I don't really know what to say. I feel like everything that has been said about this case, I've already said like a million times ad nauseum. So me just repeating myself over and over and over and over again, I'm a little bit tired of it, but we'll just be patient. Okay, that's all I'm going to say. We'll just be fucking patient. And it's kind of a mess. Is there anything else that I wanted to talk about before I go, though? Let me think. We talked about Sarah Boone. Was there another? I don't think I covered this on stream, but I talked about it very briefly in my Discord about Becky Hill. I think she's charged with was it like 67 ethics violations? I don't know. I know you guys are so sick of Becky Hill. No one cares about Becky Hill, but I think it's so interesting. I want to know what's going on with Becky Hill. I want to know what's going on with her son being charged, if he indeed was listening on conversations and recording them, you know, just so he can give his mom updates. Like, I'm so interested in this Becky Hill stuff, but yeah, she's been charged and we'll see. I mean, at least she stepped down as a Kelton clerk of court. But I wonder if they're like, hey, Becky, maybe you should step down. You know, it doesn't make sense for you to be in this position when there's been so much negative publicity about you. But yeah, I don't know. I want to hear more of the Becky Hill stuff. We'll see. Do you guys have any comments, questions, anything you want to discuss about before I head out? My physical therapy appointment isn't until like half an hour, so I'm good for a little bit. But I should probably eat lunch though. Hi, Dominique. Good morning. Time check. What time is it for everyone right now? I saw the Becky Hill, all of the ethics complaints. They say there might be criminal charges later. Let's write to our favorite killer, Sarah Boone. Send her love. Alleged killer. I like your hair today. Oh, thanks. It's just bunned up. It's I just rode out of bed, you know, just how it be sometimes. How long to prove Sallyport records are only reliable when we want them to be? She's no longer Courthouse Becky. She's about to be Jailhouse Becky. Oh, man. Yeah, I want to know what's going on with her and her son. You know, 5:37 p.m., 5:37. Oh, y'all are on East Coast time. 7:40 on a Saturday. Oh, Dominique, Australia, maybe? Oh, Storm. Let's check out the, is it socials? What's the command again? Let's test it out really quick. Oh, is it SM? YouTube, Twitch, Instagram, TikTok. Is there a character limit? Why is it like that? Okay, I mean, it's weird. Stream Elements is kind of a funky one. You're in Australia? Oh, I want to go to Australia. I've been watching videos of like these like, you know, like there's always like this like stupid prank people on YouTube. And let me just say, Australia people, don't fuck around with them. Dude, Australian people are so fucking base, okay? Like, They escalate from 0 to 100 like real quick, and they're fucking hilarious. But yeah, certain people were funny. I like. Look up the CW motion for the job. Oh, how do I look it up? Because I tried looking up this case on their court website, but I was not getting any search results. And I don't know if I was just like fucking it up or if this court website was just like really weird. But my only way of getting the court docs are from this website called Scribed, and it's just what people upload. So maybe it's on there. Do you know if it's uploaded somewhere? I can check really quick, I guess. Commonwealth v. Reed. Added. Is this opposition? Oh, it's on X. Can you link? Maureen, are you in my Discord by any chance? Can you link it to me? Oh, yes, I did hear about that. 2 more murder charges for Rex Harriman. I did hear about that. Take care, Morton. Or do you know who uploaded it? Do you have the name of the user that uploaded it? I can search by that instead. Oh yeah, thank you. Yeah, do the thumbs up thing. No, more issues, Dominique. More issues. And you know what? The judge was asking her like straight up questions. So Sarah Boone was saying that, oh, my lawyers lied to me. And the judge is like, about what? How? How has she lied to you? Because it seems like the things that she told you are not lies. It seems like they're the truth. And Sarah Boone, she wants to be out on bond. She's saying that the lawyer has lied to her about the process of being out on bond and discouraged her and her brother from doing it, I guess. Good luck at your appointment. Yeah, they're going to do my foot casting today. I'm like, ugh, get to pay. I thought I bookmarked on X, but I can't find it now. Okay, I'll try to dig around. It's just called, is this still called Twitter? Oh wait, it's still, the address link is still Twitter. Karen Reed motion. Let me see. Is there like entirety of the motion? Okay, hold on a second. Reading Lolly's motion. This is from maybe this one. Did I find it? There's one that's like 4 pages. I want like the entire thing. Oh, it's only 3 pages? This one is 2 pages. Oh, hold on. I think I found it. Oh, I found it. Yeah, let's read it real quick then. Brandy Churchwell. Shout out to them for posting it. Okay, I'll read it. Let me see if I can find my glasses though. I mean, I can read it. It's just I don't want to strain my eye. Okay, I got my old glasses back, by the way, from my mom. But I need to get them adjusted because they're fucking tight as hell. All right, let's do the motion before we go. Let me make sure it's the right date. June 6th. Oh, where's Mr. Morrissey's name? On April 15, 2024. Oh, wait. How do I show you guys the... There you go. Does that work? Should I zoom in? Does zooming in work? Hello? Hello? Nope, it doesn't work. Okay. On April 15, 2024, the day prior to trial, the defendant provided the Commonwealth with a witness list which contains the names of civilians, police, defense investigators, and experts. On April 22nd, 2024, the Commonwealth filed Commonwealth renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts. During that week of jury impanelment, the defendant was ordered to comply within 1 week with mass R crim, blah, blah, blah. On April 29, 2024, opening statements were made. Yeah, April 29. Oh, it's the end of April. Opening statements were made and the trial testimony commenced. The defendant sporadically provided reciprocal discovery to the Commonwealth on May 1, 2024 and May 7th. Citation. The defendant has failed to comply with Mass R Crim, which requires the defendant to produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case and the identity of anything upon the expert basis of their opinion. For an automatic exchange of discovery regarding intended expert opinion evidence, the Commonwealth again renews its motion for reciprocal discovery. On April 15, 2024, the defendant identified Chris Van E, PhD, as a potential expert witness in biomedical and mechanical engineering. The defendant proffered that Mr. Van E will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR data obtained in the connection with this case. He will testify to the chronological data derived from the EDR, including key cycles and triggering events from the time period in question. However, this description fails to comply with which requires the defendant to disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. The defendant also identified 3 experts from ARCCA LLC, Daniel Wolf, PhD, Andrew Rentschler, PhD, Scott Klein, BSME, as an expert witnesses in accident reconstruction. The defendant indicated that each expert will testify consistent with the report in possession of the Commonwealth. Now, pursuant to the same thing, the Commonwealth again moves for the defendant to produce all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases his opinion. The Commonwealth also moves for the defendant to specify what each of the 3 experts did, what their independent opinion is, and what each expert would testify to. Furthermore, a voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, whereas all 4 proposed experts are biomechanical engineers and not crash reconstructionists. Now, on May 21st, 2024, the defendant provided the Commonwealth with the CV of Dr. Marie Russell, an expert witness not previously disclosed. On May 30, 2024, during the 6 weeks of trial, Attorney Little provided the following synopsis about Dr. Russell. Oh, Attorney Little is the female attorney who's also been doing some of the questionings as well. This is what they said. She has reviewed the autopsy photos, the grand jury testimony of Dr. Scordi Bello, the entirety of the autopsy report. I think Scordi Bello is the one who is the pathologist who we have not heard from yet, who has not testified yet, and we're all waiting with bated breath. All reports associated with Chloe's prior bite history, photographs of the items and evidence, and the UC Davis DNA testing results and evidence submission forms. She's expected to be called with focused testimony related to the right arm injury sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack. Wait, what? Scordi Bello? I thought Scordi Bello was the state pathologist or medical examiner. Maybe not, just kidding. Are consistent with an animal attack, namely teeth and claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from a broken glass or taillight material. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. No written reports or opinions from Dr. Russell were provided. A criminal defendant constitution's right to call witness on their behalf is not absolute and may be limited in the judge's discretion in the face of legitimate demands of the adversarial system. Let's see. The defendant filed the notice of experts 1 day before the trial on April 15, 2024, and for Dr. Russell on May 21st, 2024, with a synopsis of her opinions over a week later on May 30th, during the 6th week of trial. A judge may, in her discretion, bar these witnesses from testifying. This sanction may not be imposed without a judge's balancing the Commonwealth's interest and enforcing its procedural rules against the defendant's constitutional right to present evidence on her behalf. Ooh, I want to listen to this argument on camera. They're going to argue on camera. I want to hear from both of them. Factors in assessing such a balance include 1, prevention of surprise, 2, evidence of bad faith, 3, prejudice to the Commonwealth, 4, effectiveness of the less severe sanctions, 5, the materiality of the testimony to the outcome of the case. Oh God, why is it on one page? The Commonwealth moves to exclude Dr. Russell's testimony as the Commonwealth is prejudiced by the extremely late notice of Dr. Russell. The Commonwealth has called over 50 witnesses thus far and requests for a continuance 7 weeks into trial is impractical. In addition, jeopardy has attached. The Commonwealth is furthermore prejudiced by the defendant's decision to elicit his testimony and the surprise it has caused. During a final pre-trial hearing on February 15, 2024, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and the defense is not pursuing such a claim. It was not until April 29, 2024, during opening statements, where contrary to the court's prior ruling that third-party culprit evidence was not admissible or appropriate for opening statements, Attorney Yannetti unfairly prejudiced the Commonwealth by arguing Karen Reed was framed, her car never struck John O'Keefe. She did not cause his death, and that means that somebody else did. And then surprisingly proceeded to claim the defendant's injuries were consistent with a dog attack. In light of this, but did he object though? Did he object during I don't think he objected during the opening. I don't think there were any objections actually during opening statements. Could he have objected then and been like, oh, I thought you said you weren't going to bring up the dog attack thing? In light of this, May 15, 2024, the Commonwealth called Terry Kuhn, a forensic scientist, to testify there was no canine DNA present on the samples provided to the veterinary forensic laboratory. Again, those swabs were done on John O'Keefe's sweater. Ms. Kuhn did not render an opinion about the cause or appearance of John O'Keefe's injuries, nor offered any testimony about whether or not John O'Keefe's injuries were consistent or inconsistent with an animal attack. The Commonwealth is unduly prejudiced the defendant's intentional delays in providing appropriate discovery and notice to the Commonwealth. Furthermore, the proposed testimony of Dr. Russell may necessitate a Daubert-Lanigan hearing where the defendant bears the burden of establishing the proposed testimony would assist the trier of fact and that the methodology underlying the expert testimony is sufficiently reliable. The trial judge must also determine whether the witness has sufficient knowledge of the facts and expertise to render an opinion. Of note, Dr. Russell's expertise is with treating patients in an ER and how injuries may appear in living individuals rather than how injuries are depicted on a deceased male and in a post-mortem photograph. As for the expert disclosed on April 15, 2024, the Commonwealth again moves an order that the defendant produces the appropriate proffers, opinion evidence, and the expert reports forthwith so that the Commonwealth can adequately prepare for cross-examination. As to Dr. Russell, the Commonwealth moves for an order to exclude her testimony entirely as there's no severe sanction to ameliorate the surprise, bad faith, and outrageously delayed disclosure. The Commonwealth bears the burden of proof and production at trial and therefore cannot try the case without simultaneously working to understand and rebut testimony from experts whose report and opinions it does not have, without which the Commonwealth is prejudiced and unable to effectively prepare for cross-examination of these witnesses. I mean, we're only getting a one-sided version, and because Yannetti said that they were going to pursue the dog bite thing, but he mentioned in opening statements. But I also wonder, was there an objection made then, and did they discuss it? I don't think there was, though. Also, I would expect the Commonwealth, I would expect them to have an expert that deals with collisions, what victims look like after they were hit with a car, and have them testify, and give their expert opinion on like, oh, okay, I've worked with so many, people who have passed away, and I've examined their bodies after they've been hit by a car, and this is what it looks like, blah, 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 right? So that's what I'm hoping to hear from Mr. Lawley's experts. If he doesn't provide that, that's going to be a hard one. I don't know. We'll see. They're going to argue on Monday, and yeah. When did Yannetti say that? This wasn't pretrial stuff, so I wasn't privy to the pretrial stuff. I've seen some pretrial stuff, but I haven't seen, because they televised it, I believe. It was on streams and stuff, so during the pretrial hearing, apparently Yannetti said they weren't going to pursue the dog involvement thing. So I don't know. We'll hear what Yannetti says about that, because Yannetti could just be like, no, that's not true. You're misrepresenting what happened and what I said. So like I said, it's only like a one-sided argument. We'll have to wait till Mr. Yannetti or Mr. Jackson goes up there and argues on Monday morning. But I mean, if it's phrased the way that, Lawley is saying, That to me seems like, oh yeah, like it seems like if they weren't going to pursue it and they said they weren't going to, but then they introduced it all of a sudden in opening statements and now they want to have an expert coming in last minute, like yeah, that could be kind of like bad. But like I said, we don't have the full story here, so I'll wait until Yannetti gets over here. It said it was during the pretrial hearing for February 15, 2024. So I'm sure that's like uploaded on YouTube. Y'all can probably just look it up. All right, guys. That's it for today. I'm going to go eat, head to my physical therapy. I appreciate y'all being here. Thanks for hanging out. I hope you guys have a good one, good weekend. Next week will be a very interesting court week. I think they are, is it Tuesday that they don't have court? Tuesday, no court, but then full Monday, Wednesday, Thursday, Friday. So I might have to be a little bit picky and choosy to which testimonies we listen to, maybe. Because usually the half days help me catch up. The half days and then the no court days help me catch up. So Tuesdays, we could probably catch up on Mondays, but then Wednesday, Thursday, Friday, maybe I'll pick and choose which one we're going to do. And then, well, actually, I keep forgetting that court ends early for me because technically it's East Coast time. It ends at like, what, 12:30 to 1. So I could technically do it in the afternoon. All right, guys. Well, thank you so much for hanging out. I hope y'all have a good one. Take care. Have a good weekend. And I'm going to, if you guys are here on Twitch, thank you, Turbo. Hello. I'll try to stream on the Twitch if I have time. I have some videos I want to film and all that stuff. It says February 15. During a final pretrial hearing on February 15, 2024, when asked by the court whether there is any dispute about the canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not going to pursue such claim. It was not until April 29, 2024, during opening statements, was when Yannetti brought up, oh, you know, it's maybe a dog did it. So that's what Lolly's talking about. All right, guys, have a good one. Take care. I will see you guys maybe this weekend, maybe next week.